Yes.
My lord, I may be allowed to mention item number 34. My lord, due to some personal difficulty, I have taken consent from the petitioner part.
I'm for the petitioner. No objection.
You're
In the-
for petitioner.
Yes, Your Lordship.
In the meantime,
On the prayer of Mr. T. Learned Counsel appearing on behalf of respondent.
yes,
Number,
private respondent,
private respondent. List this matter after
3 weeks.
3 weeks. Mr. So-and-so, Learned Counsel for petitioner is present and has no objection. This after
Fine.
3 weeks.
Most of them.
And Your Lordship, I would like to mention one item number 31.
31.
Yes.
Ah.
The matter may be listed after 2 weeks. Consent has already been taken.
On the consent of the Learned Counsel for the respondent,
Petitioner.
you are for petitioner.
Yes.
On the consent of the learned additional PP, the petitioner prays for and is granted 3 weeks time. This matter after 3 weeks.
3 weeks.
Lordship,
Master,
I beg to mention item number 35.
35.
Yeah, from petitioner side. In this case, we have to file the rejoinder. Matter is for containing the voluntary retirement from service
You are for
for petitioner.
prisoner.
Yeah.
MS so-and-so learned counsel submits that she may be granted 3 weeks time to file
3 weeks.
3 weeks
3 weeks.
to file affidavit in reply.
Rejoinder. Filing for rejoinder.
Ah. Is
And,
it something different?
Yes,
Rejoinder is
yes,
something different.
Not much.
Okay.
And Lordship, there is one more item.
Rejoinder. Ah.
Yes, one more item number 39.
39.
Yes.
Yes.
Uh,
On the prayer of so-and-so, learned counsel for the petition list this matter after 4 weeks. 4 weeks?
yeah. Or
39?
yes.
Yes. Yes,
My
next.
chocolate.
May Lordship.
Yes.
I would like to mention item number 2, Lordship.
2.
Lordship, this matter may be taken, Lordship, on list next week, Lordship. I'm taking the consent, Lordship.
Why?
Lordship, I am not prepared, Lordship. This is a case of my friend, Lordship. So brief is given to me, Lordship. Next week, Lordship.
It's nothing. You are claiming compensation.
Not compensation, Lordship.
What?
Here, Lordship, here is the allotment, Lordship. Late
Yeah.
allotment, Lordship.
Okay, allotment.
Yes, Lordship. Next week, Lordship.
This has been given, allotment is given to the.
Yes, Lordship, saying that my allotment is overlapping, Lordship.
Go back to civil court. Nothing.
Lordship, Lordship, at least, Lordship,
On the prayer of Mr. Deeba,
Next week, Lordship.
learned counsel for the petitioner, who seeks to withdraw his writ petition.
no, Lordship. No. Next week, Lordship. Our go, Lordship. Next week,
On the
Lordship.
prayer of Mr. Deeba, learned counsel for the business matter after a week.
And Lordship, one more, Lordship. Item number 47, Lordship.
Yes.
Lordship, on Lordship, this matter may fix on 15, Lordship.
Why this?
There are no further adjournments.
Lordship.
Why this? The return
There's-
submission, it has been heard by the
That's what I'm saying.
ordinance bench.
Yes. Now the written,
Let- let
that
go
written,
back-
that written
go back
submission
to
is
the-
useless now.
Yeah.
Lordship, this is my
I'll not
seat.
accept, I'll not accept, if I had to hear it, I'll not accept your written submission.
Can't.
Lordship, 15, Lordship. Last opportunity, Lordship. Fix,
No,
Lordship.
it
Fix
could have
matter,
been-
Lordship.
Or else you could have been, keep it as a part heard.
No, my lord, what happened was, on the merits, argument was not advanced, only on 2 technical grounds. I submitted on that day also, RFA cannot be argued in this manner. But Honorable Court of Appeal, if they are not arguing, then you just submit written argument. I submitted on that day, earlier, so that the Honorable Court will pass the order. They submitted on the day it was fixed, so that was how it was, could not be taken up. These written arguments are useless now.
Lordship, on 15, Lordship. Lordship. On 15, Lordship. Last chance, Lordship.
What is this? It's a issue, a surviving issue is there.
Yes. That
Okay.
land has been in a status quo since the last 30 years. 2 plaintiffs have died.
Because of pendency of this.
Yes.
Decrease.
Decrease there is a been state.
Yes,
Okay.
Since 1991 dispute.
On the prayer of Mr. Jeebam, learned counsel for the petition, list this matter on 15 for hearing.
Yes, Lordship.
Mr. Deepang, learned counsel for respondent
One, R1.
is present. Appellant, huh? It's appellant.
Yes, yes.
Jeebam for appellant, huh? I think,
Lordship, till
anyway,
interim may be
we'll
continued.
see on 15.
Till interim may be.
I know
continued,
there's not
Lordship.
much issue, only 2-3 evidences will be enough.
Till interim may be continued. Lordship.
Interim order pass earlier symptom.
8 years on interim.
Much.
Lordship, I beg to mention item number 5.
Yes,
I have taken consent from the petitioner side.
you are for respondent.
Yes,
MS so and so, learned counsel appearing on behalf of respondent. Press for and is granted 2 weeks time to for what? 3 weeks.
okay.
Why you are adjourning? Why you are asking for adjournment?
Since the learned counsel is out of station.
On the ground that the learned counsel, leading counsel in this matter is out of the station. Due to personal difficulty.
Interim may be continued.
Interim order pass others will continue. You record his name, Mr. Jeebam for learned counsel of petitioner is present. Interim order to continue.
If you may please, Your Lordship, I beg to mention item number 12 and 13 on behalf of Mr.
12
D.
and 13.
Yes, Your Lordship.
Hmm.
On behalf of Mr. D. Soki. Mr. Soki is out of station, Your Lordship. He's appearing
Then if it is 12 and 13,
12 and 13,
Okay.
Your Lordship. Mr. Soki is appearing for respondent number 6 and item number
on the
13.
prayer of MSD Tamuk, learned counsel appearing on behalf of Mr. D. Soki, learned counsel for the prime respondent. This matter after 4 weeks.
Obliged, Your Lordship.
Interim order, interim order to continue. Interim order first, earlier will continue.
May Your Lordship, I beg to mention item number 27.
27,
Yes.
yes.
I'm for the petitioner. The conducting counsel of this matter is unwell, so matter
On
may
the
be.
ground of, petition, the counsel for the petitioner being indisposed, MS so and so, learned counsel for the petitioner. Press for listing the matter after 4
One-
weeks,
1 week. 1 week.
after a week.
And also
Yes,
your,
list this matter after a week.
and also your Lordship, item number 37 and 38 on the same ground.
Same order, 37 and 38,
Yes, Your Lordship.
yes. You are here, you are also,
Yeah, here in this case, we are respondent.
respondent, have you taken the consent?
Yes, Your Lordship.
Okay. On the consent of the learned counsel for the petitioner. MS so and so, press for and granted, press for listing the matter after 4 weeks. 4 weeks, 3 weeks,
1 week. 1 week.
1 week. Press allowed this the matter after a week.
My Lordship, I beg to mention item number 45,
45,
on behalf of B. Picha, Lordship. Due to personal
Mr.
difficulties, Your Lordship.
prayer being made on behalf of Mr. B. Picha, learned counsel for the petitioner. List, for
3
listing
weeks.
the matter after
3 weeks, Your
3 weeks. Praise the Lord, list this matter after 3 weeks.
Obliged.
45,
45, yes,
Yes.
Lordship.
Mayor Lordship. Your Lordship, I beg to mention item number 14.
14.
Yes.
Yes.
Leading counsel is out of station, Your Lordship. Taken the consent of the order 40.
On the prayer of Mr. So and so learned counsel appearing by Mr. K. Taja,
Yes, again.
K. Tagya, learned counsel for the petition. List this matter after 4 weeks.
After 4 weeks. Your Lordship, there is interim.
Hmm.
It may be continued.
Interim order, personal relation to continue.
Lordship, I beg
Yes.
to mention item number 52.
52,
Yes, leading counsel Mr. L. Verma is having some medical issue and he's out of station. I'm appearing for respondent number 6.
where is the petitioner?
I am petitioner.
You have no objection.
No objection, but
Huh?
Lordship, if there is an interim order also. No objection. But short
On
date
the-
may be given.
On the joint prayer of this learned counsel for the petition, list this matter after 2 weeks. 2 weeks. 2 weeks.
Lordship, there is interim order also.
Interim order was earlier, so continue. I thought I'll dispose of this matter. Where is Mr. Kamru?
Yeah,
Who is in health permit? Medical program. Seriously? Okay.
Lordship, item number 4, Lordship.
Hmm.
I'm here for respondent number 2, Lordship.
Yes.
I'll file reply, need some more time, Lordship.
On the prayer of MS so-and-so learned counsel appearing on behalf of respondent number,
2, Lordship.
respondent number 2. List this matter after
4
4
weeks.
weeks,
Yes, Lordship.
so as to enable her to file appropriate response.
Again, Lordship, item number 6 and 7 also.
Yes.
Here, my senior is not well today.
Who is your senior?
T. Tapak, Lordship.
Okay. On the MS so-and-so learned counsel appearing on behalf of Mr. T. Tapak learned counsel for the petition submits that her senior Mr. T. Tapak learned counsel for the petitioner is unwell today,
Yes, Lordship.
for which she prays for listing the matter after 6 weeks.
Yes, Lordship.
4 weeks.
4 weeks.
4 weeks. List after 4 weeks.
Much better.
Prayers allowed and list after 4 weeks. Yeah. Yes, madam.
May I please, your lordship? My lord, by last order, passed by this honorable court, there is,
Respondent do not file affidavit.
yes, they have not
Isn't
filed
that they have
affidavit.
nothing-
So, my lord, my prayer is that this matter may be heard today.
my lord, we'll be selling together, my lord. I don't have any objection. It's a central standing council, my lord. They have to accept it.
Including you, respondents including you. Have you filed the?
My lord, we have filed the affidavit. Yes, my
Okay.
lord.
No, my
He
lord,
is in your favor.
they have filed affidavit earlier. This case was amended, lordship.
Ah,
In that amended petition, they have not filed.
okay.
So it amounts to not filing now.
Then, my lord, we have to see, my lord, what part was amended. My lord, basic facts was same, my lord.
Facts is almost the same.
Same, my lord. Yes.
What was amended?
Lordship, some part of the prayer.
Prayer is for what?
Prayer is for lordship, for directing them to give, to pay rent,
Compensation.
rent or hire from the date of the actual possession. Also to give interest, lordship,
My lord.
as per section
80.
80 of the Lara Act.
2000. So basically, they're asking mandamus against the central government, my lord, not the state. So,
Also to give interest, lordship.
so like,
Who is applying? Yes, central government.
central government is the Marco.
We'll take after some time. Let
My
it
lord.
come.
I also have matters in the other court after some time.
What is to do? Without hearing,
Uh,
because you said he is the main respondent.
Yes. My lord.
Then you
Can you start?
I
So
can
this-
start, but
I'm sure if he comes, he will ask for a time to file affidavit.
no, he has filed affidavit already. It's the other respondents who have not filed.
Who are the other?
The land department.
Okay. Do you entitled? Are you entitled for rent as per the 2013 Act?
Yes, lordship.
Rent.
Yes,
Okay. We'll see.
yes. Obliged.
May I please, Your Honor?
Yes.
Lordship, regarding this matter, the leading counsel Iqbal Hussain Soikia, due to his illness and sickness, is unable to appear. And last time, the opposite counsel already filed the affidavit in oppositions. We prepare for the counter reply, Your Honor. So give a 2 weeks time to file the same, Your Honor.
To reply.
Reply or the written argument, whatever it is.
Mr. M. Bagra,
M. Bagra.
learned counsel for the
Lordship.
petitioner, submits that the leading counsel, Mr. I. Serki, learned counsel, is indisposed today. And also, for which he prays for listing the matter after 2 weeks.
After 2 weeks.
Mr. He has also prayed that he may be allowed to file affidavit in reply to the affidavit in opposition filed by the respondent.
Yes, madam.
Prays it list this matter after 2 weeks.
Much obliged, ma'am.
Here, Your Lordship, the state has challenged the discharge order passed by the learned court, trial court on 13/5/2022 by way of criminal petition, Your Lordship, under 482. The other side is not represented today.
Who is for the other side?
Your Lordship, Wakalatnama was filed as per the office note, Your Lordship.
Without hearing them, we cannot. Isn't it?
Yes, Your Lordship.
Discharge.
Discharge.
Are you taking it seriously?
Yes, Your Lordship. It's a, Your Lordship, the investigation has been carried out by the SIT, Your Lordship.
According to trial court has taken a mini trial while framing the charges.
Yes, Your Lordship.
It's well, if the mini trial has been taken,
Yes.
then rather, in fact, it's clear that whether the case is made out or not.
Yes, at this stage, the court can only presume that whether offense has been committed or not.
It's okay.
That much, Your Lordship.
Anyway, it's a case of discharge. You cannot,
Yes, Your Lordship.
hear the matter without them.
Yes, Your Lordship.
Heard Mr. T at the learned counsel for the learned additional PP appearing for the petition state. None appears for the respondents despite service of notice. However, as a since the matters relates to and the challenge is the state had challenged the discharge order of the learned trial court
13/5/2022,
whereby the respondents have been accused. How many respondents?
Total, Your Lordship, 6.
Discharged, all of them.
Yes, Your Lordship.
The respondent accused persons have been discharged as a last opportunity. The respondents are given. The matter is adjourned as a last opportunity. This after 4 weeks.
4 weeks. Obliged.
Yes, madam.
Your Lordship, I am on behalf of respondent.
What do you want to say? You make your submission. What is the matter?
The matter is about make appeal.
Yes, I know.
The
I've seen
matter
it.
is today for admission, but the plaintiff counsel is not present. So next date may be given.
Plaintiff counsel.
Yes, I am on behalf of respondent.
You are claimant.
Yes, claimant.
Who is the plaintiff? If you are claimant, who is the plaintiff?
Insurance company.
The insurance company cannot be a plaintiff. Are you
Then
sure?
yes, Your Honor.
Are you sure he is a plaintiff?
Plaintiff. Appellant.
Appellant.
Sorry. Yes, appellant.
So what was the award?
Judgment was first 8 lakhs to be given to the claimant.
On account of?
Huh?
On account of?
On account of Lordship,
None appears for the appellant on call. MS. Your
The-
name, please.
Tiaku.
Tiaku, learned counsel for the claimant respondent is present. MSc appeal stands. The MSc appeal is dismissed for non-prosecution. You make a
Achha.
claim, go and claim.
Lordship, this
Yes.
is an appeal against the quantum of compensation
Hmm.
awarded by the MSCT tribunal,
Hmm.
0.
Hmm.
Your Honor, in this case, the facts are not disputed
Hmm.
regarding the death of the deceased and the
Yes.
liability of the insurance company.
Yes.
Your Honor, here the only issue to be decided is that the claim has been filed by the elder brother of the deceased, who is around 85 years.
Hmm.
So only, and the learned member has awarded compensation under the head loss of dependency.
Okay.
So Your Honor, here the elder brother of the deceased is the Gaubura. He has
Hmm.
own independent source of income. He's not dependent on the deceased. So the learned tribunal had aid in awarding compensation under the head loss of dependency.
Yes.
That's my case, Your Honor. And regarding this, I'd like to place judgment of our own Guwahati High Court.
Hmm.
Your Honor, in this case, the claim was filed by the elder brother of the deceased, who had his independent source of income. So he was awarded a compensation under the head loss of.
Is there
share.
any evidence that he was dependent on the deceased?
No,
No evidence.
no evidence on record to show that he was dependent on the deceased.
Claim petition was filed by the younger brother of the deceased. During the pendency of trial,
Hmm.
younger brother of the deceased also died.
Hmm.
And subsequently, my present respondent, he was substituted.
It's okay. It's okay if it is, that was during the pendency only.
Yes.
Who had the defendant on then defendant on the deceased that time when the claim was filed?
The younger brother of the deceased.
That was filed by the younger brother.
Younger brother, deceased, he was a defendant, but unfortunately he also died.
Yes.
But end of the thing, elder brother substituted.
A way of succession. Succession model. Succession model.
Heard Mr. G. Kato, learned counsel for the petitioner, and also heard Mr. H. Lampu, learned counsel for the claimant. Only one
Yes.
claimant respondent. Admit and list poll hearing after 3 weeks. You are here, both of you are there. After 3 weeks.
Your Honor,
3rd of
there's a
June, ready?
stay application.
Huh?
Stay application. One.
Hard on the hard so and so they stay. Huh? Will stay. All right. We should fix the hearing and we'll stay that thing. Huh? Stay at that thing. What is that? Aye. Heard Mr. G. Kato, learned counsel for the appellant. Also heard Mr. H. Lampu, learned counsel for the claimant respondent. Applicant, huh? Applicant, appellant. By filing this application, the petitioner, the applicant has prayed for stay of the judgment and award dated 29/6/2020 passed by the member motor accidents claims tribunal, Lower Subanji oblique Kurungkume oblique Kamle oblique Karat, Dadi district in MSCT case within bracket Z of Z05 of 2021. Consider. It's okay, you are appearing. Since you are admitted the appeal, we'll hear it. Instead of, it's a matter of 1 week, one round. It's okay. What do you say?
You know, in case they might be filing, that's the reason why we need to stay on this.
It's okay, it's a matter of 1 month. We'll hear the matter. All right. Having considered the grounds of stay of the impugned judgment and award dated 29/06/2023, which this court finds to be German, Germane, and also considering that the MSc appeal has been admitted for hearing, fixing the date of matter on 03/06/2024. I deem it appropriate to stay the judgment and award dated 29/06/2023, passed in MSCT case number within bracket Z of 05/2021. What is the last sentence? I deem it appropriate. I deem it appropriate to state as so and so. Accordingly, the order dated so and so, 29 so and so. Judgment and award dated so and so, passed in so and so, remain state. IA so and so, stand disposed of, allowed and disposed of. You don't have to pay something.
Your Honor, we're
Have you
cutting
paid?
quantum, we have to pay, yes.
You have already paid. You have already deposited.
No, straight away check.
Huh?
Check we have deposited.
You have deposited.
Obviously.
Yes, sir.
Lordship, respondent lordship supposed to file affidavit lordship, so it's not required lordship. Last occasion.
What is your claim?
And lordship, well, dispose of the land composition lordship.
Yes.
The additional deputy commissioner lordship Kamba decide the title in favor of the sole respondent lordship. Title of the land. Lordship.
Title of the land.
Yeah.
While disposing of the
Land compensation.
land compensation.
Yes. Well, award of the land compensation.
What authority does he has?
Lordship.
What authority does the additional deputy
Lordship.
commissioner has?
He has authority to disburse the land compensation.
Disburse.
Disburse, lordship.
Already
Yeah, lordship. Disburse, lordship.
money has been deposited.
Money has received by the sole respondent lordship.
Yes.
And well, disburse, lordship.
It's basically apportionment.
Yes, lordship. Title of the land is given to in favor of the sole respondent lordship. So
Was it not a different proceeding?
no, not different proceeding, lordship. Title was
Let us see where is the impugned order.
Today, lordship, I impression that lordship, suppose my friend to file affidavit lordship.
You have taken a granted to the court.
Yes, lordship.
This court will not taken up the matter.
No,
Will
lordship.
take up the matter.
No, lordship, no, that will not, lordship. Yes, I just informed lordship. I got impression that my friend supposed to file affidavit lordship.
It's up to him.
Yes, lordship. But lordship, as
You can you force him?
lordship, if lordship next week lordship, I am not prepared lordship. Is also lordship.
Where you were last night?
Last night lordship,
Still the hangover of polling?
no lordship.
Huh?
This matter lordship, I prepared lordship from other matter lordship, which was also my friend is taking the exam.
What are the other methods? We'll hear it now.
Taji lordship.
Huh?
Taji case lordship. Taji case lordship.
Where it is?
Lordship, item number 5 lordship.
We'll take it up. We will take it up the matter.
Lordship,
Yes, what do we want? Who is for the state?
No state lordship,
This is what, CRP?
CRP lordship, civil
Okay.
division lordship.
On the prayer of Mr. B. Typo the learned counsel for the respondent, sole respondent. List this matter after a week, after 2 weeks, so as to enable him to file appropriate response to the
Yes, sir.
revision petition. Mr. G. Bam, learned counsel for the petitioner is present. List accordingly.
Master.
Yes, why you are keeping it pending? We'll direct it to process. Let the government decide. Yes, yes. What, saying what?
Right of way, under right of way. That 10%. That's what we are.
Have you informed that your case cannot be considered because it falls under the right of way? You inform him, let him take appropriate action. You just cannot keep it like that. When did you apply?
In the year 2015.
Heard Mr. B. Picha, learned counsel for the petitioner. Also heard MS T. Wangba, learned state counsel, who submits that she has filed the affidavit on behalf of the 3 and 4. By making by stating that the land which the petitioner has sought for allotment falls under the right of way at Bomdila Township. Mr. She in view of the above, she submits that in view of the land being within the falls under the right of way, the grievance of petitioner could not be considered. Mr. Mr. B. Pitcher, learned counsel, responded that there's no except. Have you seen the affidavit statement in the affidavit?
Yes, ma'am.
Except bio of the affidavit in this present proceedings, no communication has ever been made to the petitioner so far as the alleged statement that the land is under falls under right of way. Whereas the petitioner has applied for allotment in the year 2016 after the petitioner allowed to construct his RCC building, right?
Yes.
Same. That's same.
Same.
RCC building way back in 1998. By accepting advance penalty of rupees 2,000,
Yes.
right?
Yes, sir.
This stuff. We'll keep it pending.
My lord, I had the instruction to
Withdraw.
Yes, my lord.
Are-
Because they are processing.
Say,
But with liberty to file.
what Mr.
What?
will impose you cost now
No, my lord.
for
I was
wasting,
able to
wasting,
submit, my lord.
wasting,
My lord
wasting
was fasting.
2 minutes.
My lord.
Heard Mr. B. Picha, learned counsel for the petitioner. Mr. B. Picha, learned counsel for the petitioner. Press for withdrawal of the writ petition with a liberty to file a press. Mr. MS T. Wang, London State Council appears for respondent, all the respondents. The respondent number 3 and 4. Please. Prayer of the learned counsel for the petitioner is accepted. Is allowed. This stuff accordingly, writ petition stands disposed of on withdrawal with a liberty as spread.
Obliged. Okay.
Lordship, actual
Yes.
pleading is completed.
Yes,
This matter may be fixed for hearing after 3 weeks.
we'll hear you now.
No, I am not acquainted with the fact.
Yes,
I am not acquainted with that.
We'll take it after some time. What is the matter?
Actually, this matter, leading counsel matter, see motives.
It's okay. We'll hear you.
I am not acquainted.
You make yourself acquainted by within 1 hour. We'll hear you.
My lordship.
Do you have the brief?
No, I don't have the briefs.
You give the second position copy. We'll take you after 1 hour. After 1 hour, we'll hear you.
Your Honor,
Withdraw. Nothing
no,
survived. All elections over.
Lordship, I have a prayer to make, Lordship. The senior counsel is little bit not feeling well today, so
Not keeping well.
yes, his health is not good, so this matter may be adjourned.
Is that that?
Sorry,
Is that that?
no. Impertinent,
Impertinent.
yes,
He's not keeping well.
yes.
He's when? Since when?
Since,
Seriously?
yes, Your Honor.
No, seriously, not
Yes.
keeping well, or it's okay?
Yes, he's not feeling well since morning, it seems.
Huh? You know, basically, we get scared when you see this file. Okay. MS.
D. Riva,
London Counsel for the London Counsel appearing on behalf of Mr. M. Pertin, London Senior Counsel for the petitioner submits that her senior, Mr. M. Pertin, is unwell, for which he prays for listing the matter after
2 weeks, Your Lordship.
2 weeks. Mr. Peter Pope and all of you.
For private respondents.
Respondent number 3 to 23.
3 to 23, and then
No, she's with me.
Mr. Peter Pope and so are present and have no objection.
It is,
Prayer.
nothing survives rightly said.
For 29, 2029,
Published.
praise the Lord, list this matter after 2 weeks.
May I please, Your Lordship?
Yes.
Lordship, this application is under section 438 in connection with Simpu PS case number 13/2023.
Yes.
Registered under section 120B, 419, 420,
Yes.
468, 471, 379, 34 of IPC. Lordship, original FIR is at page 16, Lordship.
Your Lordship, on the last occasion, CD was called for, Your Lordship. The CD is in the court of CGM, Your Lordship. Therefore, I could not produce the CD today.
What is to be done?
Your Lordship may fix this matter after 1 week, Your Lordship. Meanwhile, he is also in interim, Your Lordship. That may be continued.
Lordship, this honorable court was
He's-
pleased to allow interim on 4th of March 2024.
2 weeks.
And subsequent.
We will produce the case.
Case diary, Your Lordship.
We don't have to pass any order.
Your Lordship may record the WT message that
No.
has been.
Heard Mr. So-and-so, learned counsel for the petitioner. Applicant. MS learned additional public prosecutor for the state by producing the WT message. Has produced the copy of the WT message, which indicates that the CD of the present case is before the learned CJ for UPA, for which she prays for listing the matter after 2 weeks.
Lordship,
Praise the Lord, list this matter after 2 weeks.
Lordship, interim may be
Produce
continued.
the learned additional people to produce the CD.
Lordship, interim may be continued.
Interim order passed unless it continue.
Deeply.
Highly obliged, Lordship.
Item number 19.
May I please, your lordship?
Yes.
My lord, due to unavoidable circumstances, my lord, I am appearing from Guwahati in this matter.
No issue. No issue.
My lord, oblige. My lord, here, my lord, the main petitioners before your lordships are the, my lord, family member of the main accused, my lord, who was arrested, and this honorable court was pleased to grant him, my lord, a regular bail earlier occasion, my lord. And there was a, my lord, a monetary dispute with the, my lord, main accused. And my lord, matter was in the meantime, my lord, compromised, and he, my lord, given undertaking to pay the money, my lord, disputed money. And this honorable court, my lord, also found, my lord, then this is a monetary transaction, my lord, between the parties. Therefore, my lord, bail was granted to the main accused, my lord. But while, my lord, his house was searched, my lord, as we are, my lord, joint family members, some money were also, my lord, recovered from our bank account, my lord. Therefore, we are issued, my lord, a notice under section, my lord, 41A, my lord. And having, my lord, a receipt of this notice, my lord, we approach before this honorable court, my lord, praying for pre-arrest bail, my lord. I may be allowed to, my lord, identify the petitioners with the main accused, my lord, who was arrested and released on bail, my lord. He was, my lord, petitioner number 1 is the, my lord, his brother, my lord. 2 is also brother. 3 is his wife, my lord, and 4 is his cousin brother, my lord. I have stated the entire facts at paragraph, my lord, 4 of the petition, my lord. Lordship, kindly I may be allowed to read out paragraph 4 of my petition, my lord.
Why don't you file a separate petition?
My lord, they have filed, my lord, a joint petition, my lord, and this honorable court was pleased to grant them interim bail, my lord.
It's okay. This court is of the view that you should have filed a separate petition. Are you a joint accused? Are you a joint accused?
Joint accused, my lord.
Joint accused?
Yes, my lord. In the same case, my lord.
Joint accused?
Yes, my lord. And they were issued notice, my lord, under section 41M.
Yes, your lordship. Your lordship, in the CD, your lordship, though the main accused were granted bail, your lordship will see that there are prima facie material against all of them, your lordship. In fact, when he was granted the interim order, he had appeared only on one occasion, your lordship. Thereafter, on the many occasions, the IO has called him up for interrogation, your lordship. However, he did not appear on those occasions, your lordship. Your lordship will also see that he being the co-accused himself, he has filed, he has as a bailer for other 2 accused, your lordship.
Who? Which number? Which applicant number? Petition number?
Petition, your lordship, the main 2 accused, your lordship, that is, if I may be allowed to bring the files, your lordship. Lordship, also there is, your lordship will, if I may brief the story, your lordship. There was, in fact, on the first occasion, there was a agreement between the complainant and the accused.
According to you, after obtaining the interim bail, he's not cooperating.
Oh, not cooperating.
They are not cooperating.
None of them. In fact, the main accused who has been granted bail.
May I submit, my lord? They are, my lord, government employee, my lord, and they appeared, my lord, and paying, my lord, cash money before the learned CGM, my lord. They were released on, my lord, interim bail, my lord.
Government employee of what?
My lord, petition number 1 is a doctor, my lord, and 2 others are, my lord, in the state government service, my lord, and 3 is, my lord, wife of the, my lord, main accused, my lord. And this honorable court, my lord, lordship, kindly I may be allowed to, my lord, refer the bail order granted in respect of the, my lord, the main accused person, where, my lord, at paragraph, my lord, 6, it is, I also, my lord, forwarded this order before your lordship. Here, my lord, categorically held that, my lord, this is a monetary dispute between the parties, my lord.
It's okay. It's okay. We'll see that. But the problem is, after obtaining the interim bail, you are not cooperating with the investigating authority.
Definitely,
do
my
you
lord,
say?
they will, definitely they will cooperate. Perhaps, my lord, this notice was not properly, my lord, sent, my lord. Otherwise, my lord, they will definitely cooperate.
We're fixing it next week. If we find that you are not cooperating, then we'll reject the bail application
My lord.
or vacate
My lord,
the interim.
my lord, another, my lord, time maybe.
Mr. A.M. Burbuya, learned counsel for the petitioners. Also heard MS Tijini, learned additional PP for the state. It is submitted by the learned additional PP that the petitioners of the accused persons are not cooperating with the investigating authority after having been considered granted interim bail by this court on 14/03/2024. In view of the learned counsel is granted a week's time to take
Appear, my lord, before the IO, my lord.
Huh?
1 week time may be allowed to appear before the IO, my lord. They are from Hailakandi, Assam, my lord.
To place on record. No, to obtain, to make his response. List this matter after 2 weeks, after a week. Got it?
My lord, any date may be fixed, my lord.
The learned additional PP has submitted that you are not cooperating. Despite
My lord,
several
definitely I will take
notices.
instruction, my lord. They are
So
from
next week, whatever you want to say, whatever you want to report, whatever is there, we'll see, we'll consider and we'll pass appropriate orders. Next week.
My lord, kindly any date may be fixed, my lord.
When do you want? Next week, we'll see next week.
No, my lord, I am from Guwahati, my lord. From my convenience, my lord, any date may be fixed, my lord.
You are sitting there and what more convenient you are asking?
No, my lord, exactly as per date, my lord, I will appear before your lordship.
Yes, we'll fix the date. Let him come. It's very difficult.
14.
BC.
14.
14. 14 is what? 14/5. 14/05.
My lord, kindly, my lord, interim order may be continued.
14/05, we're fixing it. And you have to appear in person. I mean, you have to appear here.
My lord, kindly, my lord, interim order may be continued, my lord.
What is there? You have been granted. Interim order process, alias in consent. Okay.
Deep level, my lord.
Yes.
But, this statutory time period is also over, my lord, for filing the charge sheet, my lord. 90 days, more than 90 days in custody. Till now, no FIR, no charge sheet has been filed, my lord. Otherwise, also, my lord, even if married, my lord, last occasion, my lord, there was disclosed from the city during the hearing of the bail application that the alleged victim is a major. And there is no any injury even in the medical report, my lord. And if we go by the story, my lord, the allegation that it's quite improbable, my lord. Frivolity of the prosecution case is there, my lord. But now, my lord, that's why, my lord, last occasion only for recording of the 164 statement, the matter has been again fixed for today, my lord. So by now, my lord, 90 days is over, my lord.
6, 7.
Yes.
Your Lordship, the statutory period is not over, in my humble understanding, Your Lordship, because the accused was remanded on 7/2/2024. And as on that, today is 89 day, tomorrow is the 90 day. And the whole day till 12 o'clock midnight, Your Lordship. So, however, your lordship, so far as 164 statement is concerned, that has been recorded on last occasion, this court has given an observation that only pertains to the investigation in part of the accused. Regarding 164 statement was only not done, your lordship. Otherwise, everything is done as per the status report, your lordship. And yesterday, your lordship, I've been
It has
instructed.
been recorded.
Yeah, 164 statement recorded yesterday itself, your lordship. The victim 164 statement.
You have the.
I don't have, your lordship. It was recorded yesterday only, your lordship.
Can you have that?
No, today not possible, your lordship.
So day after, would like to see that. At the same time, if you claiming default bail, you file an approved application. We'll fix it. We'll take it up day after tomorrow or day after. After 2 days, we'll take up. You file an application. Because normally we're not inclined. POCSO matter, but default bail is a matter of right. You file an application.
That part is there. Here is the very unfortunate, my lord, as on today, not even once, my lord, my application has been considered on merit, my lord. What happened, my lord? In the learned trial court below also, in the learned trial court also, my lord. What happened?
Because of POCSO, and the victim is somewhat,
my lord, there is no material. My lord. This is very unfortunate that even there being any material, the person has been put to almost 90 days, my lord.
We'll see. Day after tomorrow, after 2 days. All right. Art Mr. Arsona, counsel for the petition. Mr. Who submits that the charge sheet has not been filed even after completion of 90 days, mandatory 90 days period. Therefore, it submits that the applicant accused is entitled for default bail. On the other end, no, Mr. T at the learned additional people has on the other end submitted that the period of 90 days is yet to be over.
Yes.
As the petitioner was remanded.
Remanded on 7/2/24.
02/72. 02?
02/2/24. 2024. 7/2/24. 7 February 2024.
07/02/2024.
Yes, your lordship.
And the statement of the victim under section 164 CRPC has been recorded only on 0405. Yesterday only. Yesterday means on Sunday.
Yesterday on 4th. On 4th, your lordship.
My lord, if I count from 7, my lord, it's 90 days today, my lord.
04/05/2024 as directed by this court on 01/05/2023.
My lord, if I count from 7, my lord.
If I have an application, we'll consider, otherwise on merit, we may not. We're not inclined, normally. You file on that. All right. The two-page application. Mr. The learned additional PP is directed to produce the record as regards the statement. Do you have the records?
Your lordship, case diary is before your lordship. Your lordship. On last occasion, the case diary was retained by this honorable court. It's there in the file itself, your lordship.
It is directed to place the latest status of the matter, including the statement.
Yes, sir.
Under section 164 of CRPC. Mr. Arson, learned counsel for the petitioner is also granted 2 days time to file appropriate application. Claiming appropriate application for default bail. List after.
presence may be recorded, informant for the victim side.
Mr. So-and-so. Your name, please? Health info, informant is present. You want to say something?
Next day.
Deeply obliged.
After 2 days, fix it on 8th file.
Obliged.
Lordship, case diary is still awaited, Lordship.
Hmm?
Case diary, Lordship, is still awaited. We have not received yet, Lordship.
Are you on interim bail? No,
It's a regular bail.
regular bail, okay. From where?
It's in Naharlagan.
Nahalagan case, Lordship.
Why? Notice was issued on 29.
29.
Okay. Heard Mr. Please learn counsel for the applicant, accused, applicant. MS L. Hage, learned additional PP semesters. She is yet to receive the case diary. This is the matter after a week.
On Friday, Lordship.
After a week.
Lordship,
Next
since, I have a prayer, Lordship,
For
the alleged
production of case diary.
Lordship, I have a prayer since the alleged accused is behind the bar for 201 days. Whether Lordship, charge sheet has been filed or not, Lord, that
We'll see.
instruction will-
We'll see the case diary. Next week, after a week. All right.
I would like to.
Item number 22.
In this case, my lord, the petitioner is the assistant, presently serving as the assistant commandant first IRBN. So, my lord, in the year 2018, my lord, while serving as the my lord, officer in charge of the police station, my lord, an FIR was received by him, my lord, by the my lord, the petitioner in the item, my lord, next item, my lord, alleging, my lord, that the complainant of the present case, my lord, cheated him by, my lord, misrepresenting the fact that the 4 nose of excavator machine belonged to him and it was in the good condition, believing that the complainant in that Duimuk police case number, my lord, paid 14 lakhs amount also, my lord. But subsequently, it was found that, my lord, those machines were not in, my lord, good running conditions. All those things happened. And there were also some issues, my lord, where the, my lord, informant of this particular case, my lord, they also cheated some other person of this Yangkyong area. Then what happened, my lord? Then the this petitioner in the, my lord, next item, my lord, he lodges the FIR before the officer in charge, Duimuk police station. He being a, my lord, officer in charge of police station, my lord knows that when the FIR come, my lord, he has to, my lord, register a case, my lord, since it is a cognizable case, my lord. Thereafter, he endorsed the matter to one ASI to undertake the investigation. Pursuant thereto, my lord, the ASI Niri, my lord, he went to the Sejosha, my lord, and that excavator, my lord, that was already seized by the Sejosha police in connection with other police case, my lord. And that excavator was brought to Duimuk police station, and it is still under the custody of Duimuk police station. My lord, thereafter, my lord, the present FIR was lodged, my lord. Now the allegation against me is that I have hedged conspiracy with the one Tugung Niri, then thereafter taken the excavator machine in the Duimuk police station. And the, my lord, will see very interesting, my lord, the offense charge against me, my lord, 403, my lord. Now the 403, it says of the, my lord, misappropriation of property, my lord. Now, my lord, my lord, the machine is, my lord, still there at Duimuk police station, my lord. This is on the record, my lord. After the inquiry, my lord, this FIR was filed against me, my lord. Now, my lord, the machine is there itself, my lord. Now, the question of misappropriation doesn't come, my lord. Otherwise, my lord, 403 is a bailable offense, my lord. Now, my lord, second section is, my lord, 406, which is only the non-bailable offense, my lord. Now, my lord is saying that the breach of criminal trust, my lord. Now, where is the question of, my lord, I am, my lord, entering with any contract or anything with the informant here in this case, my lord. I was merely discharging my duty as an officer in charge of the Dumik police station at that point of time, my lord. And therefore, my lord, thereafter 182, my lord. That is also bailable offense, my lord. Now, my lord, 406 being a only one section, my lord, these sections are not at all, my lord, attracted against me at all, my lord. And my lord, since 41A notice was issued to me, my lord, thereafter interim bail was granted by this honorable court, my lord, and I have been cooperating with the investigation, my lord.
What is it, the FIR?
My lord will find FIR, my lord, against me, page number 14 to 16, my lord. It's a very long FIR, my lord.
Your lordship, sorry for interruption, your lordship. We have not received the case there, your lord.
Why?
Reason, your lordship,
What is the problem?
further 2 more days time may be granted, your lordship, to produce the case there on 9th, your lordship.
Lordships, may I say something in the matter?
Who are you?
I am the informant, Lordship, who has lodged this FIR on 22nd of April 2023, sir.
Okay.
Now, sir, whatever has been said is just a part of the story, not the entire story. The case is like this. My mother had rented 4 excavators to Mr. Neri by entering an agreement with him.
It's okay. Mr. Agarwal, we are fixing the matter on 9th.
Sir, I have a humble prayer, sir.
Additional PP,
I have a humble prayer, sir.
Just wait. Additional PP, learned additional PP is yet to receive the case diary. We'll take it up on 9th.
True,
Or
sir.
Mr. Arsona, learned counsel for the petitioner. Mr. T. learned additional PP submits that he's yet to receive the case diary. Come on. List this matter on 9th,
Yes.
09/05/2024.
Interim bail.
Deeply obliged.
Interim order for earlier shall continue.
Much.
Yes, on 9th.
Same, your lordship, 23.
All right.
Sir, I have a symbol.
On 9th, Mr. Same order. On 9th.
Okay, sir. Thank you.
The service is still awaited, your lordship, in respect of respondent number, newly impeached
When the
respondent.
service was taken? Respondent number 3.
Yes, your lordship. Earlier 3 was not impleted, but it was impleted by the direction of this honorable court, the father of the deceased.
When it was service was taken? 9. Service report respondent number not yet received. Sorry, can you take press steps?
Yes.
Heard Mr. T. learned consent for the petition. Also heard Mr. T. learned additional PP for the state. Service obvious note that 04/05/24 indicates that the service report in respect of respondent is still awaited. In view of the vote, the learned consent for the petitioner is permitted to take press steps.
It has to be routed to the PPA or APP.
Your lordship, this is not a POXO case, your lordship. It's a
okay.
criminal petition, your lordship, pertains to determine.
This after 3 weeks. 3 weeks.
Lordship, may. Lordship, the parties to this appeal has agreed to settle the matter, Lordship.
Oh, yeah.
Yes, 2 weeks time will be allowed. Lordship, we have just
not
agreed,
yet,
Lordship. The procedure is yet to be done. 2 weeks time may be allowed, Lordship.
Learned consent for the parties. No, Mr. So-and-so learned consent for the appellant.
Yes, Lordship.
And Mr. B. Typodia, learned counsel appearing for learned counsel for the claimant respondent.
Lordship.
Jointly submitted that the endeavor is being made to settle the matter after the court, for which they phrase for listing the matter after 3 weeks.
Lordship.
Praise
W.
God, list this matter after 3 weeks. Yes.
Here, Lordship, service upon all the respondents is completed, Lordship, as I have taken justice or service. On last occasion, respondent number 3 has filed their wakalat nama. They have not yet filed their reply, Lordship.
Ah. Have you filed the affidavit?
Yeah, yes, Lord.
Our respondent number 3 have not yet filed their Lordship.
Had Mr. B type with the land counsel for the petitioner. Mr. MS K. London State Council submits that she has already filed her affidavit in opposition. Already submits that affidavit in opposition on behalf of the state has already been filed. The respondent number 3 is yet to file the affidavit. List this matter after 2 weeks for admission hearing.
Lordship, I'm for the respondent.
Yes.
Already filed affidavit in opposition, Lordship.
Yes, you are representing all. How many respond? One.
Only one Lordship.
I'm on
What
behalf
is to
of
be
the
done?
Lordship, may the interim order may be continued. Interim order may be continued, Lordship.
Why? So service, only one respondent.
Yes, Lordship.
Okay, you have filed the affidavit also.
Yes, Lordship.
Heard Mr. MS so and so learned counsel for the petition. And also heard the next para. MS so and so learned counsel appearing on behalf of the sole respondent submits that she has already filed an affidavit in opposition. Has already filed the objection.
Yeah.
Mr. What is the matter?
Lordship, the matter is with regard to put stay on the proceedings of the divorce case, which is at the Court of Counsel.
No, this is for transfer.
Yes,
From where
Lordship.
to where? Where is the
From the-
matter is pending? Matters is pending where? Which court?
Khonsa Court, Lordship.
Khonsa to where? Where you are
To be
asking?
transferred here in UPA Court, Lordship. Since the respondent and the petitioner, they are both residing here in this jurisdiction, Lordship.
You are, who has instituted the suit?
Yes, we, the Lordship. Petitioner,
You?
yes, Lordship.
At Khonsa? Khonsa?
No, Lordship, the respondent has instituted the case of
Give
divorce.
us-
Yes,
give us-
Lordship.
Ah, that's what I'm saying. You see, it's a convenient of the wife only.
Yes, Lordship.
We'll transfer it.
Let me discuss with my client
Ah.
then.
There's judgment of the Supreme Court. Smita Singh. Somewhere 2002. The convenient of wife has to be considered,
Yes, Lordship.
not the husband. Moreover, you are all of you, both of you are here only now. You are permanent resident of Naharlagan.
Yes, Lordship.
And he is, I mean, the respondent is from Khonsa.
Yes, Lordship. Respondent.
Sure.
Yes, Lordship.
List for admission after 2
Lordship,
weeks.
may the interim order be continued.
Interim order for, I'll just say continue.
Obviously.
29. May I please, your Lordship?
Yes.
Lordship, I have gone through with the records, Lordship, the service upon the respondent number 3, 5, and 6, Lordship, is still awaited, Lordship.
Where the matter is?
Matter is, Lordship, basically I'm challenging the fact is that, Lordship, the multiple FIR has been filed for the same set of fact.
Ever service, heard Mr. T. Garam, learned counsel for the petitioner. Ever service report in respect of respondent 3, 5, and 6. This after 4 weeks.
Lordship.
Mr. T. Learned additional PP for the state present.
Deeply, Your Lordship.
Your Lordship, in this matter, on previous occasions, the learned legal aid counsel was directed to file and implement implementing the victim, Your Lordship.
Who is who is for?
Oh, being up, Your
Who
Lordship.
is O being up?
Yes.
Amicus,
Amicus.
is it?
Legal aid counsel, Your Lordship.
MSO being a learned counsel who has been appointed as legal aid counsel in this matter. Is not present today, Mr. This court has directed the legal aid counsel to file IA for implement of necessary parties. Mr. However, as on that, no application has been filed. Mr. MS learned additional PP is present. This matter after 3 weeks.
3 weeks. Your Lordship, if I may suggest, Your Lordship, since she's the amicus, Your Lordship, the implement can also be done by the registry, Your Lordship. So if the registry is directed to implement, Your Lordship.
Is it the procedure?
The registry can, since
Is
it's
it
the
a
jail
procedure?
appeal, yes, Your Lordship.
It gets last order. No application has been filed. No application. Mr. Next paragraph. Since this present appeal is jail, this present is an appeal from jail. Registry to implement the who? To implement whom?
The victim, Your Lordship, who is the victim, Your Lordship.
Implement the necessary party, namely the victim. in
Yes, Your
present
Lordship.
case. And let's for appropriate orders. After 2 weeks.
2 weeks. Deeply.
Lordship, I am seeking some more time to file affidavit to bring and record a death certificate of the victim.
Mr. T.
Torun.
T. Torun, learned counsel for the petitioner is pressed for and is granted 3 weeks time to file what?
Death certificate, additional affidavit in document,
To
death
file
certificate of the
additional
victim.
affidavit. List after 3 weeks. MS so and so. T. huh? For so and so. The learned additional PP is present. Yes.
May I? Your Lordship, I'm representing respondent number 34. Kindly sometime may be given to file my Bakalatnama.
What happened to the contract with the view? Have you filed?
No, Lordship, I think we don't need Lordship.
Huh?
We don't need to file Lordship. We are just perform.
What is the matter?
No, Lordship, we have filed. This is different.
Hard, Mr.
I'm for the learned counsel SK Duris.
Mr. So and so, learned counsel appearing for respondent number. Learned counsel appearing from Mr. SK there, learned counsel for the petition.
May I please, your Lordship? Lordship,
Yes, Mr.
MUB.
MUB, learned counsel appearing on behalf of, submits that he has an instruction to appear on behalf of respondent number
34.
34. And phrase for listing phrase for adjournment of the matter for 3 weeks.
Lordship,
so
may I
as to
please,
enable
Lordship?
him to find his power. This praise a lot.
Lordship, matter may be fixed for 21st May, Lordship.
Huh?
Kindly matter may be fixed on 21st May, Lordship.
We'll see. Then what is any affidavit you want to file?
Yeah, Your Lordship. I'm for the respondent number 1 to 31. Your Lordship. I'm
Mr.
yet to
So-
file counter affidavit. Your Lordship.
Want to file?
Yes.
Mr. So and so, appearing for respondent number
1 to 31.
1 to 31, who also seeks for 3 weeks time to file affidavit in opposition. State.
Because the direction of civil court.
Mr. I, an additional senior government advocate, appears for state response.
Lordship, interim may
Next
continue.
after 3 weeks.
Interim may continue, Lordship.
Interim is there, interim over?
Yes.
Interim over was earlier shall continue. Yes.
Deeply obliged. Much obliged.
Your Lordship, I have received the affidavit of 2, 4, and 5. Not 3.
Who is 3?
3 is the
Your Lordship.
EAC of Itanama, government.
Is his affidavit is required?
I'm that in
Not
order-
Mr. K. Gara. K. Gara.
Yes.
Learned counsel for the petitioner. The affidavit, an affidavit in opposition on behalf of respondent number
3.
3 and, no.
One,
Wait,
one,
wait.
2, 4,
On
and
behalf
5.
of respondent number 2 and 4.
2, 4, and 5.
2, 4 and 5 has already been filed. Has already been filed. List of MSP Pango, learned counsel for learned state counsel who
We have
submits
received, Your
that he may
Lordship,
be granted 3 weeks time to file
counter affidavit, Your Lordship,
affidavit in opposition on behalf of respondent number
number
3.
3.
Praise the Lord. List this matter after 3
Your
weeks.
Lordship,
Obliged, Your Lordship.
Interim order plus earlier shall continue.
Yes, Your Lordship.
service report in respect of respondent number 2 is awaited.
AOS service report in respect of this number 2. List after 3 weeks.
Well, can it be after 1 week? Because the
3
trial
weeks,
will.
2 weeks.
Hold on.
What is IA is for? Non appears on call. Non appears for petition on call. This after 4 weeks.
My lord.
Yes.
My lord, this application was filed under 482 for quashing and set aside of impugned order dated 12/9/2023, passed by learned special session
And
judge.
Mr. T. Tamo, London Council for the T. Tagu, London Council for the Ever Service Report. List
My
this
lord.
matter.
Respondent number 2 is a IO of the case, and as per my humble understanding, IO is represented by the PP, my lord. So this matter may be, my lord, taken up today, my lord.
Not today.
Respondent number
Lordship,
2
on
is an
last
IO.
occasion, this court has directed us to take instruction from the concerned IO, whether it will be represented by us or they will appoint an independent counsel. But to that effect, Your Lordship, the IO has written to the concerned SP for appointment of counsel without indicating anything about the appointment of the public prosecutor to represent this case, Your Lordship. This is the communication letter. Your Lordship. We don't have any instruction to appear on behalf of IO. As on that, Your Lordship.
Service completed?
Yes.
We have, Your Lordship, informed the concerned IO, Your Lordship. There was a direction from this court on last occasion to inform the IO whether the they will appoint or authorize the public prosecutor to appear in this case or through other counsel. Otherwise, Your Lordship, they are challenging the bail cancellation order, Your Lordship.
My lord, since
I'll take it after some time. I'll take it after 2 weeks.
my lord, since I'm languishing in jail and I'm a woman, my lord.
See, you
Well-
you have made him a party by name, right?
Yes.
So
IO is the informant.
He is not appearing for the IO. This is response number 2. He's seeking to, appoint a counsel of his own choice. So in that case, we cannot.
My lord, since I'm a woman and this matter has been dragging up since February, my lord.
You have made him a party by name. What can we do? And still the service report is awaited. It's not completed. We'll take it after 2 weeks. All right.
1 week.
My lord,
producing the communication, copy, a letter, a copy of the letter. Mr. T. at a London additional PP submits that he is not appearing on behalf of respondent number 2, who has been implemented by name. The letter indicates that the respondent number 2 wish to engage a lawyer of his own choice, for which he has written a letter to the Superintendent of Police, Pasigat, Asian District. That report, office note dated 26/04/2024, indicates that ID card is yet to be received back. In view of this matter,
my lord,
after 2
my lord,
weeks-
particular date may be given, my lord.
Huh?
Particular date may be given. Fix that date. My lord, on 13 of this May.
After 2 weeks.
My lord, 13 of this May.
See,
My lord, my lord, only due to cancellation of my bail, I'm languishing in jail. Otherwise,
see why you have made him as a by name. That is the difficulty you have created.
my lord,
After 2 weeks.
my lord, but
Fix that after 2 weeks.
Fix it when? 21.
21, my lord.
And today it's for fix for orders, not for admission or hearing, right?
Yes. My lord, on 21.
Hmm.
Much obliged.
What is this again? Same?
Oh, yes.
Same, Your
yes,
Lordship.
my lord.
Same.
Same day.
Much obliged.
2 cases.
Yes, my lord.
You have been arrested
Yes, my lord.
after cancellation of the bail.
Only for only that order, only the 12/9/2023 order, my bail was cancelled in these two cases, my lord.
Lordship, in this matter, on the earlier date, we were supposed to take in lead 2 private respondents, Your Lordship.
So we had not yet taken the step, Your Lordship.
Yes. Have you filed the IA?
Not yet, Your Lordship. We have not filed the
You are
IA.
seeking time.
We are seeking time, but Your Lordship, if Your Lordship is,
MS Artako, learned counsel for the petitioner. Praise for and is granted 3 weeks time to file, 2 weeks time
Lordship,
to
if-
file appropriate application for impletement.
Lordship, in this, the last order, there were 2 persons we were supposed to implead, Your Lordship. With regard to the IO, Your Lordship, since in this case, instead of impleading the IO as a party, if a status report of the case can be called for, Your Honor, because he won't be necessary as a party in this case, Your Lordship.
It's up to you. It's okay.
So, and even for the other.
You file appropriate application, whom do you want?
Actually, Your Lordship, both the persons names were reflected are not necessary party in this case, Your Lordship. Because my complaint is, Your Lordship, if Your Lordship will see, the application is that the Deputy Commissioner has not heard me before passing the impugn order and cancelling my LPC.
It's not there. You file. IO are not interested, Mr.
He can
Ikenta,
tell, yeah, he can
you
tell.
file
to
it.
be included. Yes, sir. Then-
MS T. London State Council is present.
In the
Yes.
meanwhile, if they can file their affidavit also, Your Lordship, the government, because they have not been filing.
In the meantime, it's up to them. In the
Yes.
meantime, the state respondent may file their affidavit. Managing time. Yes, I want to hear Gara, not to you. Where is Mr. Gara?
My lord.
Huh?
He is attending in another court, my lord.
Yes, what is your prayer?
In fact, my lord, this was called for, I was attending my lord natural court. So, my lord, I have a very, very limited prayer here in this case. So far, my projected case is concerned, my lord, that I am serving in the department, my lord, ICDS. Under the Department of Respondent number 2, Department of Women and Child Development. My lord.
Yes.
In the meantime, my lord, I was appointed in the SAUDC in the years 2017 until 2008.
The UDC post has been converted into?
No, my lord.
What? Converted
Yes.
into?
Despite of that, I have been appointed
Child welfare officer.
My lord, child welfare officer, my lord. That was my
You
submission.
filed the
is that-
affidavit.
That was
Lordship,
not
what is your
converted.
stand?
That-
They are saying it has been converted.
My lord.
When
They say, my lord, what my lord, my concept is that this is the
And it was your appointment on contract basis,
my lord,
right?
my lord, that I accept. I am on the contract basis. So, my lord, integrated child protection scheme is, my lord, welfare officer is under the ICPS. Difference between, my lord, the ICDS and ICPS. Now, I was a UDC in the ICDS, but later on I have been appointed as a welfare officer in the ICPS. Nowadays, my lord, this is known as Mission Vatsalya Scheme. my lord. So, what my agreement is, my lord, the integrated child development scheme has been, my lord, adopted by the government. Therefore, my lord, all the staff who are serving in this department are, my lord, they are having the same regular.
As Mr. C. Modi, learned counsel for the petitioner. Also had Mr. I read learned senior, additional senior government advocate for the state. All the respondents. Lordship. Admit list for hearing.
All of it.
In usual course. Your appointments on contract basis, whatever name may be. And you are happily accepted the officer, child welfare officer. It has been merged with.
My lord, there is. But when I come to know that, my lord, I am on the central scheme. I have been, my lord, appointed in the central.
Same thing, same thing.
He-
Not,
he-
not regular contract.
He enjoyed the enhanced skill also.
Ah. You are for respondent.
Yes, I am for.
You are for wife.
Yes, my lord.
We are allowing this.
Pardon?
We are allowing this thing. Will transfer direct for transfer.
Your Lordship.
You have
actually,
seen that
there is a-
said was short order of Supreme Court.
Yes.
The convenience of the wife has to be considered. first.
Yes, but there must be a justification for claiming
Yes,
transfer.
because she's here. She's
So-
in Naharlagan.
Lordship, just I will show only one document. Kindly see the annexure C of
No,
my
in that case,
affidavit.
we'll have to hear him first.
Yes.
My lord,
Yes.
as per earlier suggestion, my lord, this court suggests to submit written argument, my lord.
What written argument?
Last
Argument is required.
last week, Lordship has directed to submit the prepare the.
This court.
Yes.
Yes, my lord.
Not this court. Goswami.
What written argument? Unnecessary.
Okay. I have only 3 points.
Sometimes you said at Basar, sometimes you are saying at the UPI.
My lord, Basar is
Where to?
UPI. In my petition, my prayer is UPI, my lord, UPI court.
Then why
UPI
you have mentioned in your written argument, submission,
is my is of
before the district and session judge Basar, which is the jurisdictional court of Daporizam.
yes, my lord.
Yes. Sir.
Lordship can see my just 3 points.
Ah.
4 points.
Yes, you read it.
Number one, that because UPI has no jurisdiction. Why I'm saying? Marriage was solemnized in Jiro and Daporijo as per traditional custom. Secondly, Lordship, the petitioner is not residing at Naharlagan. That's why I'm draw your Lordship attention the annexure C of my affidavit in opposition. That will clear proof. Register notice cannot be served. And number 3, third point, that all the witnesses of both parties from Jiro as well as Daporijo. But Jiro will be more convenient for coming. See, if even if allowed, the witnesses has to come from Daporijo to UPI, which is more than 100 km. If she is residing, if she, petitioner can prove that she is residing here, then I cannot object also, Lordship.
Yes. What is
That is the only
proof of
ground,
your
three ground,
residence
Lordship.
at Naharlagun?
In Itanagar, my lord.
Huh?
In Itanagar, 0 point, my lord.
Itanagar 3. Where? What documents you want to show?
Yeah. Affidavit, my affidavit in opposition, annexure C,
Page,
page 29.
running page.
Yeah, 20, yes. 29.
Yes.
This,
It's okay.
even register letter was issued.
That
but
time I was
Where is your address?
present address, my lord.
No proper address.
My present address is 0 point Itanagar, my lord.
You have seen A sector near helipad Naharlagun?
Yes, Lord. That is was given only
lord,
for filing the maintenance case, and that was already disposed of last year. And
How
I'm
much
paying
you-
the
How much you are paying?
paying 15,000 per month.
Only?
Yes.
You don't have the issue? I mean, no child, children?
No charge, yes.
Well, Ella, since he had made a statement that he's staying in Itanagar.
Yes. So
Can
that
you
is-
produce any documents that you are staying at Itanagar?
I will bring, my lord. Bring this
No.
court, my lord. I'll bring this court, my lord.
In the petition, it is mentioned Naharlagun.
By tomorrow.
But Naharlagun is not.
Itanagar.
Now changing Itanagar. How this
Naharlagun,
Lordship can believe?
when I was
See, your document says shows that you have given the address on oath at Naharlagun. You are saying that now you are in Itanagar.
at the time of filing, my lord, now I left the rent house, my lord. Now I'm staying with my uncle, my lord. That is Itanagar.
Then you have to, this is very crucial thing. The residence is crucial for this disposal of this, the present petition.
Because, my lord,
Suppose if you are staying at Dapurijo,
yes, my lord.
if you pray that it should be at Itanagar, how can this be possible?
No, my lord. I am staying Itanagar, my lord.
But your document shows otherwise.
By tomorrow, I'll place my current address, my lord.
What type of, will have to, it has to be authenticated. We have to dispose of the matter today.
On my station, my lord.
Tomorrow will be some other matters which you will be delving into.
Please consider my statement.
In that case, will you produce, let him produce.
Yes, all right.
Authentic,
Yes, my lord.
whatever. Otherwise, this is, you are at Naharlagun. Now you are saying, by this address, you are now, is
That time I was,
resident of the A sector near helipad.
yeah. Now I left this rent.
Maintenance case, they brought 1 monthly rent receipt. That also only 1 month's rent receipt.
My lord,
And
because
saying
of
that I am
unable to
yeah.
bear the rent pay, my lord, I left the rent house. my lord.
We'll dispose of the matter tomorrow.
Okay.
If you can bring the authentic address proof, then we'll, or else we'll dismiss. Heard, Mr.
T. Kamchi.
He comes in London Council for the petition. Also heard Mr. M. But London Council for the respondent. The grievance in this petition, in this petition is transfer of the matrimonial suit pending before the district judge at 0.
Yes.
To Itanagar, to the court of district judge at UPA on the ground that she is residing at Naharlagun, Mr. However, at the time of hearing, the learned counsel for the petitioner submits that the petitioner is staying at Itanagar. In view of the above, let this matter be listed tomorrow. I on 07/05/2024, so as to enable the learned counsel by the petitioner to place on record, to place on record the authentic address proof of the petitioner. Mr. The matter shall be heard and disposed of on so and so, huh? On 07/20/05/2024.
All right.
If you can produce, we'll allow. If you cannot, we'll dismiss.
All right.
Much obliged.
May it please your lordship?
Yes.
Your lordship, I'm appearing on behalf of the conducting council of Appellate.
Yes.
Your lordship, the conducting council is not in the station, so this matter may be adjourned as he has submitted his letter of absence. It is reflected on the.
We are not granting adjournment on the basis of letter of absence.
On that.
What happened to your appellant?
Yes, your lordship. I'm for the
Who is the appellant?
Appellant is the.
You are appearing for whom? Who is leading this? Who is arguing the matter here?
T. Bagang.
Where he is?
He is now at SEPA, your lordship.
What he is doing?
For domestic agency, he went there. He has gone for some domestic agency.
Yes, what do you say?
Lordship, we have an objection to the adjournment, Lordship. Because, Lordship, this matter has been pending for hearing since last year, Lordship.
Doesn't matter. It's 2022 matter. Have you seen?
That is
2016-17 matter is still there.
That is there. But
You are for claimant.
we are from claimant, Lordship. Because there is
What is the case? Is it a case of death or
death, Lordship.
The injury?
Death, Lordship. My son was the deceased, Lordship. He was an excavator operator. During the road cutting, some boulders rolled down and he died, Lordship. And Lordship, there
What
has
is the
been
compensation amount?
30,94,000, Lordship. And there has been a stay that is.
Then what is the claim for? What is the ground for appeal?
Lordship, basically the appellants are claiming that the insurance company is liable to pay the payment. They are not saying that they are not disputing the challenge per se. They are only saying that the insurance company is liable to pay because the learned MSCT tribunal has decreed that they are liable to pay. So because of this issue, Lordship, this matter is pending. That who has to pay, Lordship. That is the only issue to be decided, Lordship.
Heard Mr. We'll fix some other date because his senior is not there.
Lordship, our only prayer then would be that a short day, Lordship, can be given, Lordship.
Learned counsel appearing for Mr. What? T. Bagang.
T. Bagang, your lordship.
T. Bagang, learned counsel for the petition. Submits that his senior, Mr. T. Bagang, has some personal difficulty, has some personal problem, has some personal domestic problem for which he had to be at SEPA. He accordingly prays for listing the matter after 3 weeks. Mr. Jitalo. Learned counsel for the claimant respondent is present. though Mr. Tallo made an objection to the decision. An objection of the prayer for adjournment. Considering that the Mr. Tiba learned counsel, arguing counsel in this matter has some personal difficulty. The prayer for adjournment is allowed. List this matter after 3 weeks. 3 weeks.
Lordship, his letter of absence is till 18, 2 weeks, Lordship.
2 weeks.
Much. I'm deeply obliged.
Lordship, in item number 50, I have not received the paper book, Your Lordship.
Paper book is ready.
No.
Where is the paper book? Paper book is.
No,
has
no,
it been prepared?
it has not been prepared, Your Lordship.
Huh?
It has not been prepared, Your Lordship. Also, Your Lordship, the office note says that service upon the respondent has been completed, but no one has filed their wakalatnama.
It appears for the appellant. Is he on bail?
No, Your Lordship.
Hmm?
No, Your Lordship.
Paper book has not been prepared.
There was, in fact, the matter was supposed to be listed in order, Your Lordship, since the service was to be completed, Your Lordship. Now, since the service has been completed, Your Lordship, on the last occasion, and therefore the matter was fixed for supplementary hearing. However, there was no direction as such for preparation of paper book.
Is it required?
Yes, Your Lordship.
3 years. Non appears for the appellant. Mr. MST General Learned Edition PP. Submits that paper book is yet to be prepared. Mr. Accordingly, the registry to prepare the paper book, thereafter serve the same to the land council for the parties, and list accordingly for.
Meanwhile, Your Lordship, since
Order.
Meanwhile, Your Lordship, since the service has completed, Your Lordship, no one has come forward to appear on behalf of the.
Yes. For orders. Next we'll pass approval. Yes.
Deeply. My lord, item number 1.
He wants time.
No, it's not that. His matter is also still going on. I also have a matter after that. So it may be taken up tomorrow.
You don't want to file affidavit?
No, he has filed affidavit already.
You have filed affidavit?
Yes.
Who else are not filing?
The
department, state respondent.
State respondents. Department. Matter may be taken up tomorrow because it will take a long time in court number 1, sir.
In that case, day after, we'll see. Day after tomorrow.
Day after, obliged.
On the prayer of learned counsel for the parties, list this matter on 07 and then 08/05/2024.
Obliged.
I'm sorry.
Item 1, huh? Item 1. Item 1.
Yes.
Yes.
Malad, I'm sorry, Malad. I am in item number 29 is respondent number 6, Malad.
29.
Yes, Malad. In my name may be reflected in the court list, so that Malad, on the every occasion, Malad, non-reflection of my name, Malad, measure, Malad.
29.
29, Malad. I'm for the Union of India, Malad.
29. Criminal petition.
Criminal petition.
Milena Yobin.
Quashing of criminal petition.
You add that item to the name of the Mr. M. Kato learned DSJ be reflected in the first item.
My lord, I'm extremely sorry. Item number 9, I could not, I was here actually, and due to nature call, I was busy there. So this matter has been dismissed for default. So actually, I was here.
You file an application, we'll see.
Okay, so oblige.
Today 90 days will be over. So I have the instruction for my client to withdraw the matter so that they will move before the trial court. Because otherwise, one day, an additional one day, he will have to be in the detention. 20 months.
Item 20. Item 20. I think I have signed it already. Anyway. Mr. Arsonar Learned Counsel for the applicant. Press for withdrawal of this bail application. Mr. Price allowed. Accordingly, bail application stands disposed of on withdrawal. Item 20, huh? I have said it, don't ask him to upload it, huh? This order will file. Item 20.
May I please, madam?
Yes.
Well, here I am challenging my lord, the proceedings of the DPC and subsequent, my lord, the promotion order in terms of the DPC, my lord.
Yes.
My lord, briefly, my lord, before coming to the, my lord, with all all those documents, my lord, the rule says, my lord, 5 years of regular service in the grade for promotion to the post of, my lord, assistant from the feeder cadre of, my lord, UGC, my lord.
And the DPC was held, my lord.
Yes.
And DPC has also came to a finding that respondent number, my lord, 4, the private respondent has only completed 4 years of regular service in the grade, my lord.
Requirement is 5 years.
Requirement is 5 years, and he lacks 1 year, my lord, and shortfall of 1 year, my lord. My lord, rules are, my lord, mandatory in nature, my lord. It has to be complied, my lord. Requisite length of service cannot be condoned also, my lord, and there is no relaxation by the DPC also. And my lord, by that recommendation of DPC, what happened, my lord? The DPC finds that, my lord, he has not completed the, my lord, 5 years of length of service. So what DPC has done is that, my lord, DPC has recommended with a rider that, my lord, whenever he completes the requisite length of service, my lord, he shall be considered for, my lord, regular promotion to the post of assistant, my lord. And accordingly, DPC recommended only for officiating promotion of private respondent to the post of assistant, my lord. And rule is silent about the, my lord, officiating promotions also, my lord. That's why, my lord, we have challenged the, my lord, recommendation, my lord, of the DPC and the appointment order, my lord. Now here, my lord, two things are to be looked into, my lord. The Appellate is a, my lord, registered society, my lord, registered under the Register of Societies and Registration Act, my lord. And, my lord, another, my lord, notification which is, my lord, the DPC has, my lord, taken note of is that, my lord, the OM of 2019, whereby it says, my lord, that any post, any direct recruitment post or for the post of promotion, my lord, in a group B post, my lord, the incumbent has to have a, my lord, graduation, my lord. So in my case, my lord, in case of private respondent, he is a graduate. In my case, I am not a graduate, my lord. However, before the DPC head, my lord, I have communicated to the, my lord, the authority, my lord, that I am pursuing my degree, my lord, and it will be completed within a next 1 year period, my lord. So and the rule says, my lord, rule is being made by the, my lord, this is a, my lord, registered society. So there is a, my lord, governing body, my lord. The rule making body is the, my lord, the governing body, my lord. And the, my lord, director, he is also known as the chief executive officer. He is the, my lord, authority to implement the, my lord, governing body's decisions. And the governing body has framed rules, my lord, for all different kinds of, my lord, post, my lord, and including the post of assistant, my lord. And, my lord, the rule framed by the, my lord, governing body, if, my lord, there is a, my lord, necessity arises, my lord, for amending the rules, it will also be done by the, my lord, the governing body, my lord, under Article 34 of the, my lord, Memorandum of Association, my lord. Now, my lord, without amending the rules, my lord, the DPC, my lord, without the instruction of the governing body, my lord, also the proceedings of the DPC has so moto, my lord, taken consideration of those office memorandums, my lord, whereby, my lord, requirement of degree is necessary, my lord, for the group B post, my lord. This was, my lord, taken by the DPC itself, my lord, not by the governing body, my lord, and without changing the rules, my lord. Rule provides, my lord, only class, my lord, education qualification is not applicable, my lord, for promotion, my lord. It is from the feeder cadre of UTC, my lord, and it's 100% promotion post, my lord. This is my case, my lord. And admittedly, my lord, private respondent has not completed the, my lord, requisite length of the service at the date of, my lord, DPC. So she is not eligible for consideration of promotion, my lord. And the recommendation made for officiating promotion is also illegal, my lord. And for the subsequent, my lord, promotion on regular basis after 1 year, that is to done, my lord, without, my lord, a proceeding, my lord. Even for regulation of their officiating promotion, my lord, to my respectable submission, there has to be a, my lord, proceeding, my lord, for regulation of his officiating promotion. Automatically, my lord, they cannot, my lord, promote the private respondent on attaining the requisite length of service, my lord. So, my lord, my civil service submission is there, my lord. By now, my lord, I have also attained, my lord, I acquired the qualification of graduation, my lord. And my lord, respondent has also, my lord, has the requisite length of service, my lord. My prayer will be that, my lord, to quash the DPC proceeding, a fresh DPC may be, my lord, constituted, my lord. It's a selection process, my lord, selection post, my lord. They will consider everything, my lord.
It's a selection post.
This is selection.
Merit comes seniority.
Merit comes. Seniority, my lord.
Merit.
May I proceed, my lord? My lord, before coming to that, my lord, kindly, my lord, produce, I have annexed the, my lord, these are the memorandum, my lord.
It's here. It's already here. It's already here.
My lord. Then, my lord, come to article, my lord, 13, my lord. Functions of the, my lord. Before coming to the facts, my lord, that will be in internal page 10, my lord. Functions and power of office bearers of the agency, my lord. The chairman of the governing body shall preside over all the meetings of the governing body. He will also guide and supervise in general the working of the agency. For convening the DPC for the for selection of the post, my lord, either it's a direct recruitment or for the promotion, my lord. And powers, my lord, at Article 14, my lord. Powers and functions of the general body, governing body, my lord. The general superintendence, direction and control of the affairs of the agency shall be vested to the governing body, save as herein expressly provided all the duties, power, functions, rights, whatsoever, consequential and incidental or to the carrying out of the objective of the agency, he shall exercise by the governing body. In particular, without prejudice to the generality of the foregoing provisions, subject to provision memorandum of article of association, the governing body would have power to regulate, my lord, first regulate and determine matters concerning the agency. Two, to make, amend or repeal any bylaws relating to administration and management of the affairs, my lord. And my lord, then Roman 10, my lord, next page, my lord. To these are the powers of the governing body, my lord, to determine remuneration and condition of services, my lord. I am, my lord, for the condition of services, my lord. Conditions of services are, my lord, it includes, my lord, the recruitment rule, my lord. And finally, my lord, come to, my lord, Article 34, my lord. As because rule-making body is also vested with the governing body, my lord. And a special power is given to the chairman to make amendments also, my lord. But subject to that, my lord, he has to take ex post facto approval from the governing body, my lord. In my case, my lord, no such amendment was ever done, my lord. Article 34, page 21, my lord. May I read, my lord? Page 21.
Yes.
Change in rules, my lord. The rules of the agency may be altered at any time by a resolution, my lord, passed by majority of the members of the agency present and voting in any general body meeting of the agency which shall have been duly convened for the purpose, my lord. The modification rules shall be deemed to have come into force on the day on which they are passed by such resolution, my lord. Why I am showing this, my lord? Because the rules are never, my lord, amended, my lord. The OM is being automatically, my lord, taken by the, taken in the, my lord, DPC proceedings by the, my lord, committee, my lord, without any change in the rules, my lord. Now, under my lord, Article 13 and 14 and, my lord, 15, the rules has been framed, my lord. My lord, kindly for a moment peruse the rules, my lord. Lords, you will find the rules at, my lord, page 70 and 70, my lord. Altogether, there are 33 posts, my lord, for which rules has been framed, my lord. But I am, my lord, only concerned with the rules of existence, my lord. Page 70 is the, my lord, the first page of the recruitment rule, my lord. Recruitment rules, my lord, different, 33 different posts, my lord. The rules has been framed, my lord. We are concerned with, my lord, page 71, my lord. Name of the post, my lord. It is the rules, my lord, framed in the year 2013, 1/9/2013, my lord. Name of the post, my lord, assistant, my lord. Number of post, 1. Classification, group C, my lord, non-gazetted ministerial appellate service, my lord. Now, my lord, they file an additional affidavit saying that, my lord, by now, the post of assistant is a group B post, my lord. Let it be, my lord, I am not disputing this at this stage now, my lord. Now, serial number 5, whether selection post, non-selection post, selection post, my lord. The merit cum seniority, my lord. Age of the MLS, serial number 7, education and other qualifications required for direct recruitment, not applicable. Whether age and education qualification prescribed for direct recruitment will apply in case of promotee, not applicable. Period of probation, not applicable. Method of, my lord, it is important, my lord. Serial number 10. Method of recruitment, whether by direct recruitment or by promotion or by deposition, transfer, and percentage of vacancies to be filled by various methods. 100% by promotion from serving UDC, having 5 years continuous service in the grade, 4 degree holders, and, my lord, in case of non-degree holders, 8 years continuous service in the grade, my lord. And, my lord, I was, my lord, appointed as a UDC on 1/3/2008, my lord. And DPC held on 25 to 2020, my lord. I will come to that, my lord. And I have already, my lord, completed the requisite length of service, my lord. As because 8 years of requisite length of service, as because I am not a degree holder, my lord. And the private respondent was promoted to UDC only on 19/1/2016, my lord. And she lacks 1 year, my lord, length of service, my lord. If departmental, serial number 312, my lord, if departmental promotion committee exists, what is the composition? Head of office, chairman, under secretary powers, assessors, and deputy director, appellate, my lord. And this rule has been signed by the, my lord, chairman, governing body, appellate, my lord, on 13/11/2013, my lord. And, my lord, the, my lord, OM, lordship will find at page 43, my lord.
43.
43, my lord. Because of the OM, my lord, they have denied my promotion. At page 44, my lord. Second last paragraph onward, my lord. No, my lord, from the page 44, first paragraph onward. And whereas the order of this suspension of application of office memorandum dated 28/1/2014 has expired on 27/5/2019 on completion of 4 years period, which was effective from the date of issue of OM of 2016. In 2014, there was the OM was initially issued, my lord, whereby, my lord, it was said that all the officers has to complete the, my lord, the degree within a period of, my lord, 4 years, my lord, for consideration for promotion to the, my lord, for the Group B A post, my lord. And whereas on no, my lord, then, my lord, this was, my lord, ultimately, my lord, given effect, my lord. The above decisions are brought to the notice of all the ministers, department, organization, office under the government of Arunachal Pradesh for information and compliance, my lord. Information and compliance means, my lord, to my respectful submission is that, my lord, the particular, my lord, recruitment rules has to be amended, my lord, for compliance, my lord. Just say that, my lord, it will automatically, my lord, applicable to the all the post, my lord, ignoring the, my lord, recruitment rule is not, my lord, permission for to my respectful submission, my lord. Compliance is that, my lord, the authority has to, my lord, amend the recruitment rule, my lord. Now, my lord, I will, my lord, the facts, my lord. The petitioner, my lord, was appointed, my lord, as UDC on, my lord, may kindly take the dates, my lord, as LDC on 8/6/2001, my lord.
8/6.
8/6/2001, my lord.
With LDC.
Yes, my lord.
Hmm.
By an order dated 25/4/2005, my lord. Lordship will find at page.
With LDC or UDC?
LDC, my lord.
Page?
Page 33, my lord. May I read, my lord? On the recommendation of DPC held on 23/4/2005, the ad hoc services of the following JWA, my lord, is a junior work assistant, my lord, equivalent to LDC, my lord. Arunachal Pradesh Energy Development Agency, APEDA, are hereby regularized from the dates shown as, my lord. My name appears as serial number 2, my lord. And, my lord, column 3rd, my lord, date from which services were regularized, my lord, on 8/6/2001, my lord. And I was promoted, my lord, to the post of, my lord, UDC, my lord. On, my lord, 1/3/2008 by an order dated 29/2/2008, my lord, case 34, my lord. May I read, my lord? In compliance of the judgment of the Honorable Guwahati High Court, Itanagar Bench, given on 23/1/2008 against judgment against WPC such and such, Miss Tanyang Yama, who was promoted as UDC with effect from 1/2006 through Departmental Promotion Committee DPC held on 17/11/2006, is hereby reverted to the post of junior work assistant with effect from such and such in the scale of such and such. In her place, Miss Rupa Taksing, the present rate petitioner, my lord, is hereby promoted to the post of UDC in the scale of such and such with effect from 1/3/2008, my lord. Even for the promotion to the post of UDC, I have to knock the door of the court, my lord. And the court has directed me to promote me, my lord, with effect from 1/3/2008. Accordingly, my lord, I was promoted to the post of UDC with effect from 1/3/2008, my lord. And the respondent, my lord, 4 was, my lord, appointed as a LDC on 6/8/2009, my lord. At page 39, my lord. Respondent number 4, page 39, my lord. The following lower division clerks working on contractual basis are hereby appointed on officiating basis It was subsequently, my lord, regularized, my lord, on the same day, my lord, on 6/8/2009, my lord. Serial number 3, my lord. Respondent number 4, Srimati Tara Tau Munia, my lord. This is the, my lord.
Is LDC, UDC,
LDC, my lord.
UDC, LDC.
Respondent number 4, my lord. On 6/8/2009, my lord. And my lord, as a, my lord, UDC, she was promoted on 19/1/2016, page 42, my lord.
19/1.
19/1/2016, my lord. Promoted as UDC, my lord.
Page.
Type copy is page 42, my lord. On recommendation of Departmental Promotion Committee, DPC held on 31/12/2015, Srimati Tara Tau Likha Lower LDC is hereby promoted to post of UDC, my lord. And my lord, therefore, my lord, on anticipation of one vacancy for the promotion to the post of assistant, my lord, I file a representation before the authority, my lord, on 7/2/2022. Lords will find it page 49, my lord. For my consideration, my lord, for promotion to post of assistant, my lord, which was also duly received by the authorities, my lord. May I read, my lord? Paragraph 2, my lord. Yes, sir, I have been working as UDC under your department since 1/3/2008 with a great hope to be promoted in the post of assistant in the near future. Moreover, it is to inform that I have already completed 13 years of service as UDC with proper satisfaction of my superiors, my lord. So, in that anticipated vacancy, my lord, I represented, my lord, for my consideration of promotion, my lord. And my lord, my lord, representation, my lord, is my lord 79, my lord. Sorry, my lord, the annexes are haphazardly, my lord, page 79, my lord. Intimation of pursuing, my lord, my graduation, my lord. It was
It
submitted.
doesn't matter. Admittedly, you had not completed when it was.
My lord, in their counter affidavit, my lord, the authority is now saying that, my lord, I have not intimated that I am pursuing the, my lord, graduation. That's why, my lord, I want to show this representation. On 10/2/2020, my lord, I made a representation, my lord, which was also received by the authorities, my lord. Page 79, my lord.
79.
79. It is to inform you that I am pursuing my graduation through Indira Gandhi Open University, IGNOU, Nahar, and course is going to be completed by month of December 2020. The photocopy of the acknowledgement card issued by IGNOU is enclosed herewith for reference. And bottom, my lord, it was received by the, my lord, administrative officer of the APEDA, my lord, on 12/2/2020, my lord. And now, my lord, I have obtained the documents on DPC proceedings and the promotion orders, my lord, through RTI, my lord, and all the requisite documents, my lord, including the, my lord, recruitment rules, my lord. My lord, the DPC lordship will find it, my lord, Page, my lord, 51, my lord.
51,
51, my lord. The minutes of DPC you will find it, page, my lord.
61.
No, my lord, page 61, my lord.
Hmm.
May I read, my lord? Minutes of DPC may I read, my lord? During 13th meeting of the governing body held on 6/3/2019, it was decided that the existing vacant post of the accountant, superintendent, plant operator, and execution attendant in the agency will be filled by promotion, regulation from the existing staff, contractual staff without fresh recruitment for DPC agenda successor. Therefore, departmental committee DPC was constituted by order dated 18/2/2020 with the following members and date of DPC which was fixed on 25/2/2020 in the office chamber of the director of the at such and such. These are the, my lord, the members, my lord. The members of the DPC gathered at the scheduled place and on 25/2/2020, it was seen that one post of the superintendent, one post of accountant, and one post of assistant group B non-gazetted posts are vacant, which would be filled on promotion from eligible cadres. It was also seen that 10 posts of plant operator, madam, we skip this matter. And next paragraph, madam, the recruitment rules of the above post state as follows, madam. The DPC has considered the recruitment rule which I have shown just now to your lordship, my lord. The rules of assistant, my lord, and he quoted, my lord, here. Assistant 100% by promotion from serving UDC, having 5 years continuous service in the grade for the degree holder, and in case of non-degree holder, 8 years continuous service in the grade, my lord. This rule has been, my lord, considered, my lord. This rule is, my lord, of 2013, my lord, which is annexed at page 71, my lord. Now, my lord, further, my lord, proceedings of the DPC at page 63 for the, we may ignore the rest, my lord, because there are other posts, my lord. Page 63 is the post of assistant, my lord. May I read, my lord? Page 63. Srimati Tara Tao Unia.
63,
my lord. These are the considerations, my lord, and findings.
the recommendation of DPC.
Before that, my lord, the findings, my lord. Page 63. Srimati Tara Tao Unia. Education Commission BA. She has the required education qualification, but 1 year short in service length, my lord. This has been, my lord, in the notice of the DPC also, my lord. It is their finding, my lord. And now my finding, my lord, in my case, my lord, serial number 2, Rupa Taksin, my lord, education qualification class 12, date of appointment as a UDC 1/3/2008, working in the establishment branch, does not have the requisite education qualification. In terms of rule, my lord, I have the qualification, my lord. It requires 8 years length of service, my lord. But by virtue of those OMs, my lord, I don't have the requisite qualification, my lord. of graduation. The recommendation of DPC, my lord. Now it is important, my lord.
Page.
Same page, my lord, last paragraph, my lord. The above listed candidates are the UDCs voting in the establishment branch since long, but among them, Srimati Tara Tao Unia, respondent number 4, is the only candidate who is graduate. She has completed 4 years, my lord, in the post of UDC, my lord. 4 years, my lord. In the post of UDC, whereas as per RR, the required service period of promotion to the post of assistant for a graduate is 5 years, my lord. She has obtained such and such. Srimati Rupa Taksin has completed more than 8 years in the post, but her qualification is class 12 plus, which is not in conformity with the government norms for Group B post issued by memorandum such and such in class of 29/8/2019, my lord. Madam, may skip this and does not qualify. Hence, the DPC recommend Sri Tara Tao Unia, respondent 4, UDC for promotion to the post of assistant on officiating basis, my lord. On officiating basis in her own pay scale of the UDC till she completes the minimum required tenure of 5 years, my lord. Here, my lord, my respectful submission is that, my lord. DPC ought not have considered her case because she does not fulfill the requisite qualification of 5 years in terms of the rules of 2013, my lord. And DPC would not have recommended for her officiating promotion, my lord. As the rule is also silent about the any officiating promotions, my lord. If some persons have not having the requisite qualification, he or she can be given officiating promotion, my lord. Rule is also silent, my lord. Despite that, my lord, a recommendation has been made for officiating promotion and the till she completes the minimum requisite length of service, my lord, with a future rider, my lord, which, my lord, to my respectful submission cannot be, my lord. As because, my lord, at the date of DPC, the incumbents has to be, my lord, qualified under the rules, my lord. And accordingly, my lord, the promotion order was issued on, my lord, 26/8/2021, my lord, page 51, my lord.
Page
51, my lord. The promotion order, my lord. DPC was held on 25/2/2020 and she was given promotion, my lord, on 26/8/2021, my lord, married, my lord. Consequent upon the recommendation of the Departmental Promotion Committee, DPC, in its meeting held on 25/2/2020 and subsequent approval of the competent authority and on completion of 5 years service as UDC, Srimati Tara Tao Unia, respondent 4, is hereby promoted to the post of assistant in the pay matrix of such and such with admissible allowance and under the government of orders and process with effect from date of issue of this order. Here, my lord, in this context, my lord, my submission will be that, my lord. First, my lord, DPC would not have the authority to, my lord, recommend for officiating promotion and with a further rider to regularize her promotion if she on the date when she completes the requisite length of service, my lord. To my respectful submission, even if officiating recommendation is being made, my lord, for regularization of the promotion, my lord, there has to be another DPC or a selection process, my lord.
Even if they rely on the earlier DPC.
Yes, my lord. And therefore, after coming to know about this, my lord, promotion order, I made a representation before the authority, my lord.
Page 51, no, promotion.
Promotion 51, my lord. Page 52 is my representation, my lord. May I read, my lord? to the director, my lord, prayer for cancellation of DPC meeting which was held on 25/2/2020 and subsequent.
Yes, what do you want to submit from here?
From here, my lord, last paragraph, my lord.
Hmm.
Therefore, your good office may a cancellation of the DPC meeting held on 25/2/2020 and subsequent approval of the competent authority on completion of 5 years service as UDC of such and such promoted to the post of assistant on 16/9/2001 and conduct to a fresh DPC and my name may be placed before DPC in the interest of justice. Ends of the law, my lord. This was, my lord, submitted by me, and ultimately this was also, my lord, disposed of by an order dated, my lord, 11/10/2021. Lords will find at page 76, my lord. This
76.
76. Disposal order, my lord, of my representation. Dispose on.
This is also your challenging.
Yes, my lord. 11/10/2021, my lord. Now, findings are that, my lord, from page 71, my lord, or 77, my lord. This is very important, my lord. From the bottom, third paragraph, my lord, page 77, my lord. May I read, my lord?
Yes.
Whereas DPC observed that the post in question carry pay matrix level of 6 to 9 and they are classified under Group B post. The post of assistant and accountability matrix level 6 and post of superintendent carry pay matrix of 7, my lord. Thereafter, my lord, whereas APEDA has no separate service rules of its own framed as on date. Instead, follow the CCS rule, orders, directives of the government, Arunachal Pradesh, since the inception of this agency in 1996. It's a very false statement, my lord. And I have already shown your lordship the recruitment rule they followed, my lord. And in the DPC proceeding also, my lord, that rule was taken consideration, my lord. In the disposal order, they said that, my lord, they don't have a separate service rule, but they follow the CCS rules and orders, my lord. CCS rule does not speak of the promotions, my lord. Conditions of the promotions, my lord. And therefore, my lord, whereas on scrutiny of the records and documents of all incumbents who were in zone of consideration to the post of assistant, it was observed by DPC that both the candidates number 1 and 2, namely Rupa Taksim and Milo Nari, another person, my lord, who were zone of consideration for post of assistant have qualification of class 12 and class 10 pass, respectively, and they do not have the required minimum education qualification graduate required for the post as per government order. The candidate as serial number 3, namely Tara Tao Unia, was found to have required education qualification of graduation for the said post, which is applicable in the case of direct recruitment and on promotion. Hence, her name was recommended by DPC and she has been appointed to post of assistant on completion of 5 years as per rule RR. Again, he said as per RR. Contradicting himself, my lord, by the authority, my lord. And fact remains that, my lord, the RR of 2013 was in consideration before the DPC, my lord. The undersigned has perused all the relevant documents and details thoroughly as mentioned above and found no loopholes in the DPC process. The recommendation of DPC was made considering all the rules, orders, and directives of the government issued from time to time, and the claim of Rupa Singh UDC in form of representation dated 21/9/2000 does not hold, my lord. Accordingly, my lord, my representation was rejected, my lord. And ultimately, my lord, I have obtained the, my lord, graduation certificate also, which was submitted to the authorities, my lord. My graduation certificate will find as page, my lord, 80 onward, my lord. And provisional mark sheet is at, my lord.
It's okay. Are you denying this? Are they denying this?
No.
Certificate?
Only they are denying that, my lord. I have not intimated that I am pursuing the, my lord, graduation, my lord, which is in fact not correct, my lord.
It doesn't matter. Information only. Okay.
These are the my submissions, my lord. Because, my lord, rules.
Ultimately, you obtain your
degree, my lord.
Degree one. On 16.
16/12/2021, my lord. Now, my lord, they have filed a counter affidavit, my lord. The respondent, my lord, represented by my lord, senior government advocate, my lord. My lord, my learned friend, whether he is appearing as a government advocate or as a, my lord, the counsel for the, my lord, agency, my lord. My lord, this has to be clarified first. Anyway, my lord. Now the counter affidavit says, my lord, paragraph 3, my lord, onwards, my lord. Admitted, my lord, paragraph 3, my lord. Admits that, my lord, the recruitment rules, my lord, at paragraph 4, my lord. The writ petitioner respondent begs to state that under the method of recruitment as per RR at serial number 10, my lord, just seen, my lord, 100% by promotion from serving UDC having 5 years continuous service in the grade for degree holder, and in case of non-degree holder, 8 years continuous service, my lord, in the grade, my lord. Then, my lord, kindly turn to next page, my lord. My lord, I have just shown the powers of the, my lord, governing body, my lord. The rule-making authority lies with the, my lord, governing body, my lord. And there is no such direction by the governing body whether to adopt those OM or not, my lord. The DPC in its own motion, my lord, has taken note of the OM, my lord. Lordship, that has been admitted in paragraph 3, page 3, my lord, of the continuing paragraph, my lord. Last paragraph. Therefore, DPC held on 25/2/2020 made a reference to the RR for the post of extent and also to the above orders of the government of Arunachal Pradesh during the time of conduct of DPC. There were 3 department candidates who were in the zone of consideration for the promotion to post of extent. My lord, DPC took note of the, my lord, RR 2013 and also the above order. Above order is OM of
Office memorandum.
2019, my lord.
Office memorandum.
Office memorandum, my lord. The DPC could not take, my lord, in its own motion, my lord, the OMs, my lord. This has to be, my lord, adopted by the governing body, my lord, to my respective supervision. Because it's in, my lord, registered society, registered under Registration of Societies Act, my lord. It's a body, my lord. And rule-making authority is the governing body, my lord. If governing body, my lord, directs that this will be applicable, then it's a matter of a different issue, my lord. Here, my lord, the DPC take consideration of those OMs, my lord. And paragraph 5, my lord. Here, my lord, last page, my lord, last paragraph of page 4, my lord. He admits that, my lord, there is a shortfall of 1 year, my lord, in the affidavit itself, my lord. And paragraph 12, page 9, my lord, they say that, my lord, the rules, my lord, the notification OMs, my lord, are automatically, my lord, applicable under the my lord, establishment of the APEDA, my lord. Paragraph 12, my lord, may I read, my lord? Page 9, my lord. That with regards to a statement made in paragraph 12 of the requisition, the answering respondent begs to state that it is true that APEDA is an agency of the government of Arunachal Pradesh registered under Societies Registration Act 1860, and all the resources required to run this agency, like the salaries, wages, and funds of the for implementation of the scheme, are funded by state government and central government. Therefore, all instructions, rules, notifications issued by government of Arunachal Pradesh are followed and became effective in agency 2. As a result, the existing rules and procedures are altered or changed automatically as per government order, instruction, notifications, madam. And to my respectful submission, it cannot be automatically applied, madam. And even for my lord, has gone through the Article 34, my lord. Even for amending rules, it has to be by the my lord, the governing body, madam. By a board of governing body, madam. It cannot be, my lord, automatically applicable, my lord, to the my lord TPC, madam. But these are my submissions, my lord, because my lord, to sum up, my lord, the OMs were never adopted, my lord, by the state government, my lord. Even if it is adopted by the my lord APEDA, my lord, rule has been not amended, my lord, under Article 34 of the my lord, Memorandum of Association, my lord. So rule stands what was in the year 2013, my lord. It was never amended, my lord. Even after, and my lord, under the rules of 2013, my lord, he has completed only 4 years of requisite length of 4 years of length of service, whereas the requirement is 5 years of requisite length of service in the grade, my lord. And DPC would not have recommended for her official promotion for assistant, and subsequent promotion order is also vitiated, madam. And my respectful submission will be that, madam, the DPC recommendation and the promotion order may be set aside, and a fresh and a direction may be issued for a fresh convening of the DPC, madam, considering all these aspects in accordance with the rules, madam. Madam, if necessary, madam, after submission of the my learned friend, I will place the judgments of the Supreme Court, madam. Only on this point, madam, the requisite length of service is a mandatory, madam. And my lord, the executive instructions, my lord, cannot, my lord, supplement the rules, my lord. These things, my lord, I will place. If required, my lord.
I think there is a judgment of the Supreme Court, latest, unless the office memorandum or the instruction of the government is adopted.
Yes, madam.
You have that.
Madam, I have that, but today I have not brought, madam. This recent judgment, madam.
Yes. There is with regard to
Yes.
company.
Yes, madam.
Company.
It is mandatory, my lord. It has to be adopted, madam.
In that case, government notification was not adopted.
Yes, madam.
Supreme Court, unless you adopted it.
Yes. And I will, my lord, produce that, madam, tomorrow, madam.
I think last 2 weeks back, 1 week or 2 weeks back. Yes.
Joseph, so for this, what Joseph has pointed out, legally, that I agree to that extent. In the present case, it's apparently lawsuit that adoption is not their lawsuit. But our stand is their lawsuit. So for the requirement rule is concerned lawsuit, as provided. Our stand is their lawsuit, for that too, that is the draft lawsuit requirement rule. That was not duly adopted by the lawsuit APEDA. So this is the only draft lawsuit rules which was being followed by the APEDA along with the other rules issued by the state government.
So you are saying that since you say draft rule, the state of OM will prevail.
Here what I'm submitting is lawsuit. Because APEDA lawsuit is an agent lawsuit, agent of the state government lawsuit. Because though it's created under lawsuit Society Registration Act lawsuit, but it's a government lawsuit agent, and the structure itself is lawsuit because the work is being provided by the state government only, which is drawn from the central government, and whatever the works is provided to the lawsuit APEDA, that's being educated, and the employees of the lawsuit the APEDA, those who are regular employees, they are at the par with the lawsuit, the regular employees of the state government. Their scale lawsuit, their salary, everything same. And so for their nature of their lawsuit post is concerned lawsuit. Regular post UDC, regular post of lawsuit department. This salary is being provided by the government lawsuit. And these classifications of this scale from where it has come lawsuit. This is very pertinent in this case lawsuit. Because there cannot be a different classification. Classification is same for the state employees of the state government and for these employees of the APEDA lawsuit. Classification is the lawsuit, the from where it has come from the central government only lawsuit. These are classifications of lawsuit posts. And earlier lawsuit, this very post classification was earlier it was lawsuit, this particular scale. It falls under the group C lawsuit. If lawsuit C just the additional affidavit filed by the state government lawsuit. Here this
I am not disputing whether it's a group C or B matter. Let it be a group B post matter.
Then lawsuit, if this is group B post lawsuit, because I am hearing it for the second time. My senior friend Ale also submitted lawsuit. It's admitted that group B post. Now, if anyway lawsuit for satisfaction of the lawsuit, kindly come to the additional affidavit filed by state government at page 5 lawsuit. This affidavit was filed on lawsuit 20 January 2023. Sorry, lawsuit, this is the classifications of post lawsuit. If come down to the below lawsuit, this notification was issued by the central government on 9th August 2018 lawsuit. By this lawsuit, posts have been various posts have been classified lawsuit. In classification, lawsuit will find 1 from level 10 to 18, they have been classified as a group A lawsuit. And so from 6 to 9 lawsuit, they have been classified as B lawsuit. And this post of the assistant, the pay scale which the petitioner is drawing lawsuit, it falls under the group B lawsuit. Other than this classification, there is no basis of classifications for any employees, regular employees who are drawing salary from the government lawsuit. And this is the lawsuit sole rules issued by the central government, which is the basis of the classifications of the post.
No one is disputing it.
No one is disputing that. Now, when this is lawsuit B, when this post assistant is lawsuit of B lawsuit, for B lawsuit, if lawsuit C, the office memorandum issued by the state government in year 2014 lawsuit. Here lawsuit this is issued by the chief secretary lawsuit. Here just I'll read. By this post lawsuit, all the posts, promotional posts, group A and B, the education qualifications have been prescribed as a graduation lawsuit. By this, though in various recruitment rule, for promotion, education qualification is not provided lawsuit. But by this lawsuit, that qualification has been introduced. Here lawsuit down below, the above decisions are brought to the notice of all the ministries, departments, organizations under the government of Arunachal Pradesh for strict compliance. They are directed to initiate proposal for amendment of the existing rules, service rule, recruitment rules, to insert the education qualifications, that is graduation or bachelor degree from a recognized university immediately in place of lower qualification. So this is the lawsuit, the OM issued by the state government, by the chief secretary lawsuit to the various departments, including the lawsuit, the organizations under the state government lawsuit. Admittedly, lawsuit, the APEDA is the lawsuit, the organization under the state government lawsuit. Here lawsuit. Now, there was a case lawsuit in the department lawsuit. Until unless the requirement rule itself is lawsuit, amended lawsuit. This cannot be followed lawsuit. Education qualification on the count of this education qualification lawsuit. Promotion cannot be denied lawsuit. Then lawsuit, the rule of supplant and supplement lawsuit. That was applied in some cases lawsuit, and it was held lawsuit, it's supplementing the lawsuit, the requirement rule lawsuit. Here also lawsuit will find, though as I said lawsuit, this rule is a draft rule lawsuit. There also lawsuit will find the education qualification is not their lawsuit for the post of assistant lawsuit from UDC to assistant lawsuit. So this lawsuit, very lawsuit, education qualification can be read and lawsuit. That's one of my submission lawsuit. Because the same principle, there also rule was not amended, just division bench order is with me lawsuit. In where the rule of supplant and supplement has been lawsuit applied lawsuit. This is only the supplementing law.
No, according to you, it's automatically applied. Any government decision or office memorandum, it applies automatically according to you. Because it's a government agency.
Lawsuit, what I'm submitting.
Therefore, even if there's no change in the recruitment rule, amendment rule, it applies.
Lawsuit, pass my submission. From where this group A, B, this classification, from where it comes lawsuit. This is the first thing lawsuit, root lawsuit. This is the lawsuit, this classification rules lawsuit, the central government lawsuit. When that's not disputed lawsuit, if you are of that class, particular lawsuit, group lawsuit, then you are of group B lawsuit. If you are group B, then lawsuit, the education qualification is not there in the draft rule lawsuit. But here lawsuit, it has been provided. The Chief Secretary has directed all the departments and the organizations under the state government to follow this particular rule lawsuit. As I submitted lawsuit, in the department case lawsuit, as I have copy of judgment lawsuit, their lawsuit, though in rule it's not prescribed, the education qualification is not prescribed lawsuit. Even it has been read in applying this office memorandum is supplementing the recruitment rule.
It's okay. We were not
and the same principle also can be lawsuit applied in the present case lawsuit. That's my otherwise lawsuit. What will happen? Lawsuit, just lawsuit. The employees under the government organizations and the government department lawsuit, they are by the name lawsuit, the same post lawsuit, assistant. Some of them will be having lawsuit, the education qualifications of degree, and in organization lawsuit in this particular department, they will not be lawsuit, they will not require the education qualifications of the graduation lawsuit. Now their disparity will be their lawsuit. And that consequences has to be seen lawsuit. Same lawsuit set of employees having same scale, and some are lawsuit asked to produce this education qualification, and some are not lawsuit. And this will lawsuit create some disparity among the similarly situated persons.
So problem is practically, you see, you have granted a promotion before she completes the length of service. She was, when she was considered, she was having a 5 years, graduation. But then she was falls short of 1 year to have the eligibility criteria. Just because she has the education qualification, doesn't mean you could have rejected all of them, including the petitioner.
On that issue, lawsuit, here lawsuit, the promotion given to the private respondent lawsuit. Lawsuit will find this promotion is subject to the lawsuit completions of that particular period.
You cannot. Then in that case, you could have asked her also subject to completion of the degree certificate. Because she has intimated you.
I agree on that lawsuit.
Yes.
But if lawsuit see the intimation lawsuit, intimation lawsuit, If Lordship see
No, this court is not, for a minute, not saying that, for even for a second, that you should have waited for that.
Correct.
You could have rejected
Correct,
both.
correct.
And you have a DPC thereafter.
Lordship. Lordship, the administrative.
You cannot wait for her to complete her degree so as to make her eligible. At the same time, you cannot appoint her respondent number 4, which otherwise falls short of 1 year, to complete 5 years as required under the rule.
Lordship, administrative agency was one of the ground. Lordship.
Why not her then in that case?
And apart from that,
Why not her?
What the statement?
Yeah.
What the statement has come from the department, Lordship. This intimation was not there, Lordship, at the time of.
It's okay, it's not. Even if intimation, no intimation doesn't make a difference.
No, sir.
Today we are considering it.
No, sir.
You did not complete the 5 years. Your
Right.
case has been considered.
No, sir.
Right? And she did not have the graduation certificate. You didn't consider her.
No, graduation, Lordship, it was submitted on 16/12/2021.
That's what I'm saying.
And whereas
When it was, DPC was conducted,
Lordship.
the respondent number 4 doesn't have the 5 years degree.
Yes,
I mean, the qualifying years.
Correct.
As per the rules.
Correct.
As per office memorandum, she doesn't have the graduation.
No, sir.
Equally, they still in the same footing. One of them could have rejected. Or you could have approached different, it could have been a different approach.
No, sir. Yeah, Lordship, just I would like to point only one thing, Lordship.
Ah.
The private respondent completes, Lordship, the 5 years qualifying length of service in the month of January 2021, Lordship.
Yeah.
Suppose say DPC was not conducted at that point of time, Lordship. Had it been conducted in the month of February to November, Lordship, in between February to November 2021, Lordship, then, Lordship, the private respondent would have been, Lordship, considered because qualification and length of service also.
Then
that period was there, Lordship.
Then matter could have been different.
But that chances was
Then
there.
for that, in that case, we could have considered whether your OM applies or not.
Why I'm pointing out that, Lordship?
Beyond that, I mean, on facts, on the face of it, it's your discrimination, or I mean, in between that, it's writ large.
Just I'm pointing.
Not only the rules.
No. Just I'm pointing out that, Lordship, because the private respondent would have Lordship that right to have the considerations during that period at least, Lordship.
But it's not that always.
This
Just
is
because you have completed 5 years.
just I'm possibilities, Lordship. I'm
Not
pointing out the
possibilities.
possibilities, Lordship. And this is the, Lordship, one thing which
No, according to you, since this is a government agency, any orders, any decision, any policy, or the instruction applies to the agency. That is what you are trying to say.
unless that, Lordship, contradicts the Lordship. Unless that contradicts the Lordship and contrary to the Lordship duly promulgated rules or frame rules, Lordship.
Yes.
That's my submission, Lordship. Therefore, Lordship, this 2014 OM, which was renewed in year 2019, Lordship, requiring graduation, Lordship, for Group B, Lordship. That has been read and by the Appellate while considering the DPC, Lordship. And so the point, Lordship, at that point of time.
It's not your department, it's a society. Maybe under you.
Close.
It's a society, have their own bylaws
Correct.
and rules.
Correct. That Lordship.
So nobody is stopping them, you to adopt the government decision or policy by following the process.
Lordship. That is their Lordship. But
In that case, what your submission is that since the recruitment rule is silent on the education qualification, it's supplementing.
Lordship.
It's not supplanting.
Lordship.
Now, in that case, we'll have to first decide whether this office memorandum will apply or not. Because particularly, had it been your department, I mean, state department, state government department, matter would have been different. We may look that angle also. But since a society having their own bylaws, governing body, and all that thing, So unless you adopt it, I think that's why there's a judgment. Of course, it's with
No.
regard to the company.
No, see, that I am.
Recently,
That I.
do you have that judgment?
I have no. I have gone through all those judgment laws.
Ah.
That part lawship, I am not disputing. As in very living, I have submitted lawship. I am not disputing on that lawship.
No,
But here lawship, because this is not the duly lawship frame rules lawship. It's a draft rules
See, unless you have your own rule,
lawship.
the draft rule is equally as good as your rules framed. I mean, filing rule or the existing rule. Unless you have a different rule, you have the only draft rule.
Draft rule.
It has to be followed. And in fact, you have followed it.
Correct.
You have referred it,
Correct.
including the OM.
Lawship.
That's all.
Lawship. But only I just my concern is lawship, consequences lawship. The same set of lawship employees.
Well, if somebody agrees you file an appeal, we'll decide what are the effects of this matter.
Like government and lawship, this organization also lawship, they are not.
I understand it is under your command, but under the law, it's not under your command. The organization and the service.
They are owned by law.
They have to by law.
That part I understood.
And if you say that it's just a government agency, then would have understood. It's not a government agency, we understand.
No.
It's a society, registered society.
So therefore, I was emphasizing lawship so for the classifications of the lawship scale.
We'll not go into it. Nobody is disputing it. Classification. We'll say it's a Group B post. That is no dispute. Nobody is disputing it because of this central government notification. It falls under
Since OM has not been adopted, where graduation is required.
We are not commenting on OM. We say that this has not been adopted by the society or the APEDA. It doesn't have any application. And there's no amendment of the rule. Rule requires this. And at the same time, the respondent number 4 was not equally, though she is graduate, but she was not eligible as per the rules at that point of time. Well, directed for fresh DPC as per the rules. That's all, isn't it? Yes. No, we have not. You are yet to hear you.
Yes, sir. Also, my promotion was on the basis of the OM. Also. And in that regard, also the council for the Appellate also. It will be answered. I'll be going with it.
No, it was only basis of the OM only.
Yes, also.
Isn't it?
Yes. And also with regard to the OM lawship, there were ample time lawship for the petitioner to get the graduation done.
No, we're not on that.
Yes.
That is, we're saying whether it will apply or not automatically.
Lordship, with regard to the lordship, I just will make a submission, lordship.
Yes.
That lordship, since the classification of the groups, lordship, they are accepted by the petitioners. Now the questions that here comes is whether the government orders, lordship, in the form of OM, that can be rejected by the petitioner, saying that no, this cannot be applicable to us, lordship.
No, classification is not a state government.
Lordship, in the RR, lordship, it says Group C. Now, lordship, with regard to that classification, they are accepting that it is a Group B post.
Do you say that it's a Group C?
No, lordship, they are saying that it is a Group C. They said in they have clear in the case, lordship, in the petition.
No, that is not the issue to
even
be
in the
considered
draft
here.
rule, lordship. Even in the draft.
It is not an issue to be considered in this petition.
Lordship, with regard to the doctrine of election, lordship, now they accept some other part of the classification or the government order. And in the other part, they are rejecting the other government order. Can that be, lordship, permitted?
So are you saying that it's a Group C post?
No, lordship, I'm saying that it's a Group B post.
Group B post.
Lordship, I'm saying that
Yes.
it's a Group B post. Now they are accepting that it is Group B post.
Then what?
Now whether it is
Yes, what rule will govern in your promotion?
Group B, Lordship.
Group B, no, which rule will govern?
2013, Lordship.
Yes,
Yes, Lordship, in 2013, it says Group C.
yes,
It determined the post of assistant as Group C.
yes.
Now, with regard to the common recruitment rules of the government, Lordship, they are accepting it as Group C under the pay scale of six Lordship. They are accepting the pay scale that is governing the government employees of the state of Arunachal Pradesh. Lordship, they accept it. Now, with regard to the applicability of the OM, Lordship, now they are saying that this, with regard, since they didn't have the graduation during the time of the DPC, that part cannot be rejected, Lordship. It has to be accepted, it has to be accepted as a whole, Lordship, with regard to the classification as well as the OM, Lordship.
So which one you are accepting? According to which rule will applicable?
Lordship, according to me, Lordship, as the ministerial classification of the groups are in the pay scale, Lordship, that has been accepted, like, Lordship, by the Appellate, Lordship,
even if it is contrary to the rules.
Yes, Lordship. Saying that, Lordship, the Appellate has automatically applied the Group C payment.
See, this rule has been provided. This has been made under 309 of the Constitution of India. Page 5, classification. What is your graduation requirement? Which was meant under that?
Requirement of the graduation.
That OM is under what law this has been issued? It's an instruction, government instruction.
Lordship.
Executive instruction.
Yes, Lordship.
And this rule.
Yes.
Right?
Yes, Lordship.
This classification. Read to page 5 of their affidavit.
My only submission here is that, Lordship.
Because their rule made under the 309 of the Constitution, it will apply. It applies. And the requirement of graduation is an executive instruction.
Yes, that's Lordship. Saying that, Lordship, the department, Lordship, Appellate.
See, classification
Yes.
of the rules, the classification of this pay scale or whatever, Group C or Group B, is in exercise of power conferred by the proviso to Article 309.
Yes, sir.
It applies to all.
Yes.
If you don't have a contrary rules, all right.
Yes.
It's the rule made under the Constitution, proviso to 309.
Yes. Sir.
And the OM, it's a policy of the state.
Yes, sir.
It's an executive instruction. Has it been made, is it a rule or a law made under any act or the Constitution?
Lordship, this OM has been supplementing the existing group.
No, don't go there. You just first say, you say
yes.
Doctrine of election.
Yes.
According to you, if you accept this order dated 19 August 2018.
Yes.
What is a classification of the group? Then you cannot reject that OM.
Yes.
That is absolutely fallacious because this classification is made under the in excessive power under Article 309.
Yes.
Right?
Yes.
And your OM, the OM of the government, isn't by way of executive instruction.
Yes.
There's a difference.
Yes. Lordship, my humble submission here is that, Lordship, since this Appellate, the department, Lordship, has accepted the rules, Lordship, of the...
So then you show us this requirement of graduation is made under 309 or any other act of the state, which may automatically applies.
No, requirement of that or requirement of graduation, Lordship, it's an executive order, Lordship,
then
issued under the OM, Lordship. However, Lordship, here, Lordship, since the classification of public services has been accepted.
That is issued under what rule? What law?
309, Lordship.
Then?
Yes, Lordship. Lordship, since that has been adopted automatically by the department, Lordship.
That is the rule, law made under the Constitution.
Yes. In a regard, Lordship, I'll just go with the state respondent.
It has a mandatory application,
Yes,
right?
Lordship.
Just one line,
But facts remains that they have not applied this, adopt this also. Yes. Anything else?
No, Lordship, I'll be going with the submission of the.
You may, it's interesting. You argue on the doctrine of election.
Lordship. Lordship, I didn't get the judgment ready, Lordship.
No, today we'll finish off.
Lordship. It can be posted tomorrow, Lordship.
No.
I may be able to make a few more submissions.
No, you may submit. No.
Lordship, with regard to the judgment, Lordship, I didn't get it ready. I didn't go to it.
Which judgment?
Judgment of the Lordship, DRD, Lordship.
DRD?
Lordship. That's all, Lordship. I'll be submitting.
Huh?
That's all, Lordship. I'll be submitting.
Which judgment?
Lordship. Lordship, I'll place it now. Lordship.
Which judgment?
I'll look for it. Lordship.
Which judgment you are saying? You had a judgment
Yes,
to
Lordship.
rely on.
Yes,
You misplace it.
yes. I'll just see.
I just want to clarify one thing, madam. My learned friend has repeatedly said that, madam, the rule which was considered by the DPC is a draft regulation. To my respectful submission, for the first time, madam, in the affidavit, they have come with this new plea, madam. There is a draft rule, madam. In fact, madam, the rules has been framed by the governing body, madam. And the DPC has also taken note that it's a rule, madam, not a draft rule, madam. And in the disposal order also, it never talks of draft rule matter. It's a rule matter. Under the rule.
Anyway, even if it's a draft rule, unless
Yes,
there is
ma'am.
other rule,
Yes, ma'am.
this will apply.
Okay.
But then what is they are saying is, since you have accepted the classification of the group of posts, classification of the post as Group B, which is issued by the central government, why this state government policy or the OM, it should not be applied?
I have not accepted as a matter, whole matter, but I'm not making any argument on that matter. Because, my lord, in the external affidavit, they have annexed the matter, the notification. It also says that, my lord, this should be, my lord, brought into the matter, specific recruitment rules matter. And the recruitment rules also does not.
No, that is what they are saying.
Yes.
Since you have accepted this, without bringing any amendment to the rules, because the rule says is Group C.
Group C.
But then by this notification of central government,
Okay.
which has been issued under the order, in fact, order under the rules, under the proviso to rule, the Article 309. So you have not brought a change after this, but you have accepted it
As a
But
group-
it,
Group B, madam.
is Group B.
Yes, ma'am.
So you cannot just deny the other one which is goes against you. That is what they are saying.
Madam.
Isn't it?
Yes. This is, madam, only for the purpose of nomenclature, madam, not for the rules, madam. It's only for the purpose of the nomenclature, madam. And the rule is there, madam, still, madam.
No, rule is there. Rule says it's a Group C post.
Yes, madam.
It has not been amended.
Because of, madam.
Now, facts remain that the central government has issued that this assistant has been classified falls under the Group B. That you have accepted.
Because of the,
And there is no amendment to the rules where it provides that the assistant is a Group C post. That is what they are saying.
Yes, madam. This, madam, Group C has been, madam, only nomenclature has been changed only because of the, madam, increase of the pay scale, madam.
No, that's what I'm
Nothing
saying.
otherwise, madam. Yes,
That's what I'm saying. Technically, that's why there is no, you could have accordingly amended the rules, providing that this is assistant is a Group B post, which you have not, which they have not done. That you have accepted. Now, the one thing, the OM, which they want to bring in, which has not been, without amending the rules, you are not, therefore, they said it's applied doctrine of election. You cannot do that. That is what they are submitting. On that, what you are saying? What is the submission?
My submission will be that, my lord, the source of recruitment, my lord. Source of recruitment is guided by the, my lord, the recruitment of 2013, my lord. And
No.
recruitment rules of 13 provides, my lord, education qualification, and in respect of the, my lord, there is a qualification qualification requirement, my lord, is graduation from the, my lord, but with a relaxation of 5 years, madam. And for the non-graduations, madam, is 8 years, madam. So in this matter, madam, my only consideration, madam, for prayer for lordship is that, madam, whether under the rules, madam, she could have been given promotion or not, madam. In shortfall of 1 year, madam, without condoning the, without invoking relaxation provision. In fact, the rules doesn't have any relaxation provisions also, madam. These are my limited submission, madam.
No, that's why they are saying the rules provides for, the OM provides for minimum graduation now.
Yes, madam.
So that has not been enacted. I mean, incorporated in the rules without the amendment. Now, rules also prescribe that the post of assistant is a Group C post. But then there is a order of the central government which says this pay scale and all these things falls under Group B. Admittedly, it's a Group B. So that has not been amended. So you accept that without amending that, you accept it. Now you are saying that it requires only the graduation by OM, whereas your rules provide that for graduation 5 years and for non-graduate it's 8 years, which you could have amended, but without amending, how you can apply that? That's why they are saying the doctrine of election. You accept which doesn't, I mean, which is suitable to you, and you don't accept which is against you. Equally, it should be applied. You cannot have that right of election. That this part of rule is bad.
For the purpose of my submission, I have accepted in my accepted. But in my fact, my lord, in my written submissions, my lord, in the print also, in the affidavit also, my lord, I have not accepted that, my lord, as a Group B post, my lord. I have always contested, my lord, even that, my lord, it's a Group C post, it has not been amended, my lord.
Any judgment? Any judgment?
Yes. Judgment regarding, my lord, judgment of length of service, my lord. May we don't just give the judgment.
Yes.
For the proposal minor requirement of the requisite length of service minor, the direct recruitment case 1990, two SSC 715, paragraph 34.
Direct recruit case.
Paragraph 34.
1990?
1990, two SSC 715, paragraph 34.
34.
The two length of service cannot be minor number. And it's a mandatory minor. Has to be forgotten. And two minor. In the Kokla Longer versus state of Nagaland, 2020, I will give that hard copy number. 2022 SSC online, SC 1384.
1384,
my lord.
84.
Paragraph 11, 15, 16.
On length of service.
For length of service. Then my lord,
Qualifying length of service.
then my lord, next my lord, subject my lord. This is my lord, rules cannot be substituted by government instruction. 1998 SSC 469 paragraph 3, and this was followed in minor. Mine was just saying now. We have followed in Bank of Baroda versus G. Pilani. The citation is 2022 5 SSC 612 paragraph 28, 29. Manner, second manner, 2016 5 SSC 612 paragraph.
This is also 5/612. Same.
This is 2023 SSC online.
Online.
SC 265.
You have the hard copy.
You have to give paragraph 31 minute. And this is the executive instruction can override this minute. Third minute, 2020 5 GLP 402 paragraph 34, 34, 54, 55.
34, 35.
34, 54, 55.
Okay.
Then regarding the unamended rules, state of 2017 3, 2017 3, SSC 646. Paragraph 8 and 9. It says the basic principle is that there is no rule that vacuum are to be filled up by in according with the unamended rule. That in paragraph 9 it makes clear rule applicable on the date of consideration is to be same. And in this case, reliance has been made on 1983 3 8 SSC rules I have given
1988.
1983 3 SSC. It was relied on this in the state of Tripura just given 2017 3. In 2017 3 it is relied upon that.
Yes, but you have not given that. 1993 you have not given.
1983
83 you have not given. Anyway, if it is
1983 3 SSC 284.
Okay, if it is relied in 2007, it's okay. That's all. Yes. Go to your judgment.
2021 also. SSC online. It's an Allotment High Court judgment also. Allotment 288 also.
Allotment 288.
Yes.
What does it say?
Yes.
What does it say?
Lordship, may I read also? In paragraph 53, Lordship, the government order clearly states that the directions are being issued to regulate and bring about uniformity in service conditions of the regulator and bring about uniformity in service condition of the employees of the DRDA. Because no service conditions of the employee of the DRDA or of such employees have been notified and as yet, and since the DRDA is a registered society, the rules made under Article 309 of the Constitution of India would be inapplicable. It is evident that the inapplicability of rules made under Article 309 of the Constitution of India upon the employees of the DRDA clearly means that rules made under Article 309 of the Constitution of India would not automatically be applicable upon the employees of the DRDA, since it is a registered society. However, there is no legal bar in either Article 309 of the Constitution of India or under the state government order that beneficial condition of the service pertaining to government employees made under Article 309 of the Constitution of India cannot be extended to a registered society, such as DRD who state under Article 12 of the Constitution of India. Lordship, this submission, Lordship, was rejected by the court, saying that, Lordship, the rules, Lordship, made under Article 309, Lordship, it can be extended to the registered society. Now, saying that, Lordship, in the instant case, Lordship, since the rules made under 309 of the classification, Lordship, that has been adopted, Lordship, by the department without any amendment in the rules or in the memorandum of articles, Lordship. Whether, Lordship, the certain OM, Lordship, that is issued as an executive order, that can be rejected as a part, Lordship. On that regard, Lordship,
it's not rejected a part. The rules made under 309 is one thing.
Yes, Lordship.
And the office memorandum issued by the government,
yes, Lordship,
is an executive by executive instruction is one part, is completely different.
Lordship, I understand on the
two different things.
Lordship. Lordship, however, Lordship, this I'll be relying on this judgment only.
But this is Allotment High Court.
Yes, Lordship. Two bench.
It has got only persuasive value.
Lordship.
Persuasive value we were not bound by it.
Lordship. 2021 SSC, Lordship.
We'll rely.
Lordship, I'll have the finances. Give it later, Lordship.
Pin it up and give it to
Lordship.
Yes. Heard Mr. Arsakia, learned counsel for the petitioner. And also heard Mr. Estafid, learned senior. You are counsel for the AFEDA and is it a dispute?
Lordship, this dispute, Lordship.
Learned counsel for the what
I'm
do you say?
appearing for Appellate also.
Learned counsel for the
respondent number 1 to 3. Lordship. One is the secretary, Lordship.
Non-renewal. Then in that case, learned counsel, learned senior government advocate for respondent number 1, 2, and 3. And Mr.
T time.
T Tying.
Respondent 4.
Tying.
Time.
T-A-Y-A-N. Then counsel for the respondent number 4. By instituting this writ application, the petitioner has challenged the DPC proceedings and its recommendation that 25/02/2020 and consequential impute promotion order dated 26/8/2021. What is this promotion order?
Page 51, ma'am.
Page
51.
51. Issued by the Director, Appellate. (26/7/21), issued by this one, whereby the case of the petitioner, whereby the respondent number 4 has been recommended and promoted to the post of assistant on the ground of, assistant, on the ground of violation of the recruitments 2013 of the, what is that the recruitment rule called?
Recruitment of assistant member.
Of the Arunachal Pradesh recruitment rule for assistant of Arunachal Pradesh Energy Development Agency, page 71, 2013. The next para, case of the petitioner. In brief, is that she was appointed as junior, what is call it? Junior
Work assistant.
work assistant within bracket LDC under Arunachal Pradesh Energy Development Agency within bracket Appellate, in short, bracket close. On 08/06/2001, on temporary basis initially, on temporary basis, on ad hoc basis, right? List of, on the recommendation of the DPC held on 23/04/2005 by the order dated 25/04/2025, the service of the petitioner is junior work assistant within bracket LDC, along with 4 other persons were regularized with effect from the date of ad hoc services within bracket, i.e. 08/06/2001. Next paragraph. The petitioner was promoted to the post, to the next higher post of upper division clerk within brackets UGC. With effect from 01/12/2006. No, sorry. No. Was promoted to the UGC by the order dated 29/02/2018 with effect from 01/03/2018. 2018. Mr. Next one. The respondent number 4 was also initially appointed as LDC in the Appellate. When she was appointed?
6/8/2009.
No, this is working on contract basis here upon officiating basis. Huh? Who was working on contract basis was appointed on officiating basis. That is in LDC only. On wide order dated 06/08/2009. Then promoted to UDC.
19/1/2016.
And thereafter promoted to the post of UDC
19/1/2016.
on 19 wide order dated 19/01/2016. List of. It is contended that the respondent number 4, contended by the petitioner that the respondent number 4 admittedly is junior to the petitioner in both the entry into the service as LDC as well as promotion to the post of UDC. Mr. It is the contention of the petitioner that the petitioner as a UDC how many years? Till the DPC? For 4 years, on which year the DPC was conducted for, among others, for promotion to the post of UDC, assistant from the post of UDC. It is the contention of the petitioner that as per the recruitment rule, for assistant, the post, the method of recruitment is 100% by promotion from serving UDC having 5 years continuous service in the grade for degree holders, and in case of non-degree holder, 8 years continuous service in the grade. The petitioner being completed 8 years and she being the non-degree holder is eligible to be considered for promotion to the post of assistant. The respondent number 4, though having degree holder, though a degree holder had just completed 4 years for consideration, the 4 years, having short of 1 year for consideration for promotion to the post of assistant, as the qualifying age of service for degree holder is 5 years. Mr. Next one. DPC was constituted, among others. Where is the DPC?
Case 61, my lord.
61. Among others, consisting of 5 members for consideration for promotion to the post of not among others, you put that for consideration for promotion to different posts in the Appellate, including the post of assistant. Mr. The DPC has recommended the name of the respondent number 4, who has just completed 4 years in the post of UDC for promotion to the post of assistant. To be promoted on completion of 5 years, right?
My lord.
On completion of 5 years, as no. For promotion to the post of assistant on officiating basis in our own pay scale of UDC, till she completes the minimum required tenure of 5 years as UDC. And rejected the case of the petitioner on the ground that though the petitioner has completed 8 years in the post of UDC, her qualification being class 12 pass, who is not in conformity with the government norms for Group B post, issued under the Office Memorandum dated 29/8/2019, wherein it is provided that for Group B post, minimum one must have a graduate degree, minimum graduate degree. Mr. Bracket close, Mr. Petitioner, next paragraph, being agreed, filed an representation you have filed the representation against the promotion.
Yes, my lord.
Against the DPC recommendation of DPC as well as the impugn order that it (29/2/2000). No.
26/8.
26/8/2021. 26/8/2021. There is page
51, my lord.
51. Impugn order dated 26/08/2021, whereby the respondent number 4 has been promoted to the post of assistant, ignoring the case of the petitioner. who is entitled to be promoted in accordance with the rule 2013. You are challenging this also, na?
Disposal order.
Yes. The respondent authority has disposed of the representation of the petitioner by the order dated, by the office memo dated 11/10/2021, rejecting the claim of the petitioner. And advise her to refrain from unauthentic and unsubstantiated falsehood. Being aggrieved, the present petition has been filed. I'll continue in the chamber. Unless I will not detain you. You have given two hard copy. What about the others? Huh? We'll have to find out or what. Can you get it?
I will give them the books. I will get the books.
Not books.
Madam.
Hard copy.
Madam.
It will be easy for us.
Madam.
If you are not inconvenient.
Madam.
I'll be continuing this case. You ask your junior to get it done.
Madam.
But I want today.
Madam.
If you have no
resistance of the my lord's library, madam.